Hey guys, tonight we're stepping back into the Middle Ages, but not to visit bustling markets or shining castles. Oh no, tonight we're heading somewhere much stranger, much quieter, and frankly, significantly more awkward. Imagine a courtroom. Stone walls flickering, candlelight dust motes dancing in the thin shafts of light from high windows. You settle into a rough wooden bench. The air smells of damp stone and old ink, and the silence is heavy. The judge sits sternly, scribes sharpen their quills with meticulous scrapes, and in the center of the room, well, that's where things get weird. Because in the center of the room, taking its rightful place at the defendant's stand, is a corpse. Yes, you heard that right. A dead body, on trial, for crimes it allegedly committed while inconveniently still alive. You probably won't survive this level of historical absurdity without falling asleep, but hey, let's give it a shot. So, before you get comfortable, take a moment to like the video and subscribe, but only if you genuinely enjoy what I do here. And if you're feeling chatty, drop a comment with where you're listening from and what time it is. It's always wild to see how far these whispers travel. Now dim the lights, maybe turn on a fan for that soft background hum, and let's ease into tonight's journey together. You watch, perhaps trying to stifle a nervous cough or a disbelieving chuckle as the officials move with grim solemnity around the deceased. This isn't some theatrical display or a metaphor. This is a genuine legal proceeding. The corpse, often propped up or laid out in some semblance of presence, is the accused. It feels less like a legal process and more like a macabre puppet show orchestrated by the living, using a silent, unresponsive, and profoundly finished participant. The sheer baffling reality of it washes over you. How does one even begin to prosecute a dead person? What are the charges? What is the goal? And most importantly, what possible form could justice take when the defendant has already, in a rather definitive way, served their ultimate sentence? This isn't a widespread everyday occurrence in every corner of medieval Europe, mind you. You wouldn't stumble upon this in every town square. But when it happened, oh boy, did it happen with a bizarre formality that makes you question everything you thought you knew about law logic and the limits of medieval imagination. We're talking about the kind of history that makes you pause and go, wait, did that really happen? Yes, it really did. And while animal trials where pigs or oxen were formally tried and sometimes executed for causing harm are slightly better known, the trials of human corpses remain largely in the shadowy corners of historical study. They are the truly strange footnotes, the kind that make you think the historians who documented them must have been pulling your leg. But they weren't. Imagine the scene again. The courtroom is silent, save for the rustling of robes and the low drone of the prosecutor. The corpse is just there, unmoving, unblinking, utterly unconcerned with the proceedings. Are they listening? Do they care? The very questions feel ridiculous, yet the trial insists on their participation. The idea of the person is on trial, perhaps, but the physical remains are brought in, often dressed in their former attire, or shrouded respectfully, if respectfully is even a concept applicable to a dead defendant. It's a confrontation between the living world and the irreversible finality of death played out through the rigid structure of medieval law. And the law, in its strange, evolving medieval form, was grappling with a lot. Sin, crime, punishment, redemption, the afterlife. All these heavy concepts were swirling together, sometimes manifesting in truly peculiar ways. These corpse trials weren't impulsive acts of vengeance, at least not usually. They were often rooted in complex legal or ecclesiastical justifications. Sometimes it was about clearing the name of the deceased or their family. More often, it was about punishing the memory or the estate of someone who died before they could be brought to justice for a significant crime like heresy, treason, or a particularly egregious fraud. The law, it seemed, had a long memory and a very stubborn insistence on seeing proceedings through even when one of the parties had, shall we say, checked out permanently. It was a way for the authorities, be they secular lords, town councils, or church officials, to assert their power, their jurisdiction, and their right to judge all within their domain, living or dead. Think about it from a practical, albeit unsettling perspective. Someone commits a terrible crime. Before they can be apprehended or put on trial, they die. Maybe of old age, maybe of sickness, maybe they choked on a chicken bone. The cause doesn't matter as much as the timing. They are dead. In many modern legal systems, that's the end of it. The case is closed. The defendant is gone. But in the medieval mindset, things weren't always so clear-cut. Death was a transition, yes, but perhaps not an automatic absolution from earthly responsibilities or consequences, especially if the crime had significant implications for the community, the church, or powerful individuals. If a heretic died peacefully in their bed, did that mean the heresy was simply unpunished? If a traitor died before revealing accomplices or forfeiting lands, did that mean the state couldn't touch their property or legacy? This is where the legal wheels driven by medieval logic and perhaps a touch of post-mortem spite started turning. If the living person could have been tried, why should death provide immunity? Of course, prosecuting someone who couldn't speak, couldn't plead, couldn't offer a defense beyond, being dead, presented some rather obvious logistical and philosophical challenges. But the medieval legal system, bless its convoluted heart, often found ways to navigate these issues, sometimes with remarkable creativity. They weren't just dragging random bodies into court on a whim. There needed to be a reason, a charge, a process. And surprisingly, there was often a semblance of due process medieval style. This included summoning the accused, which, when the accused is dead, involves a unique kind of administrative effort. It involved appointing representatives or lawyers for the deceased because even a dead person apparently deserves some form of legal counsel, or at least the appearance of it. It involved presenting evidence, calling witnesses, and going through the motions of a regular trial, all directed at the silent figure in the dock. The concept itself feels so alien to our modern understanding of justice, which typically requires a living sentient being capable of understanding the charges and participating in their defense. But the medieval world operated on different principles. Sin and crime were often intertwined. The impact of a person's actions extended beyond their lifespan, affecting their family, their property, and even their eternal soul in the eyes of the church. A corpse trial could be seen as a way to rectify a cosmic or social imbalance left by an unpunished crime, to reclaim forfeited property, to erase the stain on a community's reputation, or to serve as a grim warning to the living about the long reach of the law. It's a fascinating glimpse into a world that took its legal and spiritual obligations so seriously that it extended them beyond the veil of death. It suggests a belief system where earthly judgments had some bearing, even retroactively, on a person's standing or legacy. And it certainly paints a picture of a society where the law and those who wielded it had an almost absolute sense of authority, capable of commanding even the remains of the deceased to appear before their judgment. It's a level of legal overreach that feels almost darkly comical until you remember the very real stakes involved for the families and reputations tied to the unfortunate individual on trial. Consider the visual once more, the stiff, perhaps decaying form, the faces of the living participants, judge, prosecutor, scribes, maybe a crowd of onlookers whispering nervously, the absolute stillness of the defendant, a stark contrast to the legal theater unfolding around them. It's a scene that could be straight out of a Gothic horror novel, yet it was a documented, if rare, reality in medieval European history. It forces you to think about the cultural anxieties and legal philosophies that could lead to such a practice. Were they afraid of the dead person's legacy, their unexpiated sins? Were they simply obsessed with procedural completeness? All of these factors likely played a role weaving together into a legal tapestry that seems utterly bonkers from our perspective. The fact that they bothered at all is perhaps the most perplexing part. It required effort, resources, and a collective suspension of disbelief. To formally summon a corpse, to address it as though it could hear, to appoint someone to speak on its behalf, to weigh evidence against it, and to pronounce a verdict, this wasn't a simple matter. It was a complex, ritualistic performance of justice, one that underscored the seriousness with which the medieval world viewed certain transgressions, even when the transgressor was no longer capable of facing earthly consequences in the traditional sense. It was a way of saying that certain crimes were so severe, so offensive to divine or secular order, that even death couldn't provide an escape from judgment. And the judgment, as we'll see, could be quite severe even when applied to a lifeless body. The medieval legal system was nothing if not thorough, even in its most absurd moments. You're still absorbing the sheer strangeness of it all. The image burned into your mind, a dead person in the defendant's dock. But how did they even get there? How does medieval law formally engage with someone who is by all accounts finished with earthly obligations? This isn't like serving papers on a living person, is it? You can't exactly slip a summons under the door of a tomb. This is where the legal process takes another deep dive into the wonderfully bizarre. The summoning of the deceased was predictably not a straightforward affair. Medieval legal systems, while often convoluted, did tend to follow established procedures, and even death wasn't always enough to grant immunity from the preliminary steps. Before a trial could begin, the accused needed to be formally summoned. For a living person, this involved messengers' official notices, maybe even a public proclamation. For a dead body, well, you couldn't exactly send a bailiff to knock on the coffin lid and shout, "You are hereby summoned," though honestly, that mental image is pretty spectacular, isn't it? Imagine a medieval bailiff armed with a scroll standing over a grave, trying to get the attention of the dearly departed. It boggles the modern mind. Instead, the summoning often took on a more symbolic or ritualistic form. Sometimes official summonses would be read aloud at the deceased's former residence or nailed to their door. In other instances, the summons might be delivered directly to their gravesite or even to the church or cemetery where they were interred. There are accounts, though perhaps more legendary than commonplace, of legal officials literally addressing the corpse directly in its resting place, formally commanding it to appear before the court. Think of the awkwardness. "By the authority vested in me by Lord so-and-so, I command thee, deceased person's name, formerly of this parish, to appear before the court of court name on this date," followed by, well, nothing, because the deceased was still inconveniently deceased. It's the ultimate unanswered RSVP. The sheer theater of this is fascinating. It wasn't just practical notification. It was a public declaration, an assertion that death did not erase accountability in the eyes of the law or the community. It was a performance designed for the living audience, demonstrating that the authorities were pursuing justice regardless of the defendant's vital signs. It reinforced the idea that certain crimes were so heinous or had such significant consequences, especially concerning property or reputation, that they transcended the physical life of the perpetrator. Historians still argue whether these elaborate summoning rituals for the dead were primarily symbolic, meant only for the living, or if there was a lingering belief that the deceased soul might somehow be implicated or affected by the earthly proceedings. It's hard for us to grasp today, but the medieval worldview was deeply intertwined with the spiritual realm, and perhaps the lines between earthly law and divine judgment felt blurrier then. After the summoning came the question of appearance. A living defendant would show up or be brought in chains. A corpse rather reliably did not. So how did they get into the courtroom they were brought? Officials would retrieve the body sometimes from its grave or resting place, sometimes from wherever it had been laid out if the trial happened relatively soon after death. It feels incredibly invasive, doesn't it? Disturbing the dead for legal purposes. And then presenting it in court. Once the corpse was present, propped up, seated, or laid out, depending on the specific historical account or perhaps the whim of the court officials, the next crucial step was legal representation. Because, and this might seem obvious, a dead person is remarkably bad at presenting a defense. They tend to be unresponsive to cross-examination, offer no alibis, and frankly, their courtroom demeanor is terrible, just sort of lying there. So someone had to speak for them. This is where the figure of the procurator or legal representative for the deceased comes in. The court itself would often appoint someone to act on the corpse's behalf. This wasn't necessarily a friend or family member, though they might sometimes serve this role or be compelled to, but an official appointee, often a lawyer tasked with going through the motions of a defense. Imagine that job description: required legal expertise, must be comfortable arguing on behalf of a client who is literally dead and cannot provide instructions. Excellent public speaking skills preferred, even if your audience includes a decaying body. It sounds like the worst legal internship ever. These representatives had a tricky job. Were they genuinely trying to win, or were they merely playing their part in the legal theater? Again, scholarly debate exists here. Some historians believe these representatives made genuine, albeit limited, legal arguments, perhaps focusing on procedural errors in the summoning or presentation of evidence, or arguing that the deceased had died before the alleged crime could be proven, thus invalidating the trial. Others suggest the role was purely ceremonial, a way for the court to maintain the appearance of due process, even when the defendant was incapable of participating. Your Honor, you can almost hear them say, addressing the judge while gesturing towards the silent figure, my client, while perhaps not the liveliest participant today, was definitely somewhere else when that heresy occurred, or possibly too busy being dead to commit treason. The arguments must have been creative. A quirky tidbit illustrates the formality. In some trials, the appointed representative would even physically act out parts of the defense, perhaps bowing on behalf of the corpse or standing as if to object. This level of performance underscores how seriously and yet how strangely the medieval mind approached these proceedings. It wasn't just a legal process, it was a ritual, a performance of societal and legal norms in the face of death's disruption. It was as if the living world was refusing to let death have the final say, at least not without a formal argument in court first. The reasons for appointing a representative varied. Sometimes it was a genuine attempt to ensure some semblance of fairness, upholding the legal principle that even the accused deserved someone to speak for them regardless of their state. Other times it might have been a procedural necessity to make the trial seem legitimate in the eyes of the law and the public. And perhaps in some cases it was intended to protect the interests of the deceased's surviving family, whose reputation and property were often at stake. If the corpse was found guilty, the family could lose everything. So even a perfunctory defense might offer a slim chance of mitigating the damage. Consider the atmosphere during such a trial. The air, already thick with the smell of damp stone and old parchment, might now carry the faint, unpleasant odor emanating from the defendant. The representative, perhaps sweating under their robes, tries to make coherent arguments while standing next to a body that is quite visibly not paying attention. The judge, trying to maintain decorum, must address legal points concerning someone who cannot comprehend or respond. It's a tableau of medieval legal absurdity played out with deadly seriousness. This practice, while strange, isn't entirely divorced from certain mainstream historical realities of medieval law. For example, it was a common principle in medieval courts that trials often required the physical presence of the accused. This applied to both secular and ecclesiastical courts. The corpse trial, in a twisted way, was an extension of this principle. If the accused couldn't appear because they were dead, the law, in its stubborn insistence, might demand their physical remains appear instead. It speaks to a legal culture that was highly focused on form and ritual, where the appearance of following established procedures was paramount even when those procedures seemed deeply impractical. Furthermore, medieval law, particularly regarding serious crimes like heresy or treason, often had consequences that extended beyond the life of the individual. The property of convicted criminals could be confiscated, their families disgraced, and their descendants barred from certain rights or inheritances. A corpse trial, therefore, wasn't just about the dead person, it was about the living who were left behind. The trial determined the fate of their legacy, their property, and their social standing. The representative, in pleading the case of the corpse, was effectively arguing for the future of the deceased's family and estate. This adds a layer of grim practicality to the bizarre proceedings. It wasn't just philosophical. There were very real material consequences hanging in the balance. The legal arguments made by the representative would have been limited by the facts of the case and the state of the defendant. They couldn't, for example, call the deceased to the stand obviously. They couldn't ask their client for their version of events. Their defense was largely theoretical or procedural. They might argue that the evidence presented by the prosecution was insufficient or that the witnesses were unreliable. They might focus on legal technicalities, hoping to get the case dismissed on a procedural point, or they might simply make a general plea for mercy, arguing that death itself was punishment enough, which fair point. Imagine being that representative. You're paid or compelled to defend a corpse. Your client is unresponsive, providing no guidance, and frankly is starting to smell. You have to stand there and argue against potentially damning evidence, knowing that if you fail, a family might be ruined, their name blackened for generations, and their property seized. It's a high-stakes, low-reward gig. And the other side, the prosecution is arguing against a body that can't deny anything. It must have felt like arguing against a wall, except the wall was formerly a person and was now legally accused of something serious. The courtroom would be hushed, the only sounds the rustling of papers, the low murmur of the judge, and the voice of the representative, desperately trying to conjure a defense for their silent, still client. You'd watch this macabre spectacle unfold, perhaps, feeling a chill that had nothing to do with the drafty stone building. It's a vivid illustration of how profoundly different the medieval world's relationship with death and justice was from our own. They weren't afraid to drag the dead into the legal system if they felt the crime warranted it, and they created elaborate, if nonsensical seeming to us, procedures to do so. The representatives also served another purpose. They allowed the court to proceed according to legal norms. Without someone to speak for the defendant, the trial might be seen as illegitimate, a perversion of justice. By appointing a procurator, the court could claim it had fulfilled its duty to allow the accused a defense, even if that defense was delivered to an unhearing audience. It was about maintaining the facade of fairness, the appearance of due process, even in the most inherently unfair scenario imaginable. This step, summoning and representation, was foundational to the whole bizarre enterprise. It established the legal premise, however shaky, that the dead person was a valid defendant subject to the court's jurisdiction. It created the framework within which the rest of the trial would unfold, laying the groundwork for the presentation of evidence, the deliberation, and ultimately the verdict. It transformed a deceased individual from merely a body into a legal entity, once more, albeit a passive and silent one. And it underscores the deep, sometimes baffling commitment of medieval authorities to seeing justice as they defined it served, even when the accused was already beyond the reach of earthly punishment in the traditional sense. It's the legal system saying, "Oh, you think you're done? Think again. We're not finished with you yet." So you've got the legal system stubbornly refusing to let death be the final answer. You've got the corpse somehow summoned and now physically present in the courtroom. You've got the poor soul appointed to speak on its behalf, probably wondering if this gig pays enough for therapy. What happens next? The charges have to be read, formally, out loud, to the dead person. Imagine the scene. The court officials, perhaps looking a little uncomfortable, stand near the propped up or laid out body. The air might feel heavy, maybe a bit stale, certainly not helped by the presence of the deceased. A clerk or other official unrolls a parchment, clears their throat, and begins to read the formal accusation. "Hear ye," they might intone their voice, echoing slightly in the stone chamber. "We, the court of court name, hereby accuse deceased person's name, formerly of location, of the heinous crime of," and then the specific charge would follow: heresy, treason, usury, perhaps even witchcraft, depending on the time and place. The accusation is read, detailing the alleged offenses, the time, the place, the supposed actions, all directed at the unresponsive form before them. Why bother reading the charges to someone who can't hear them, can't understand them, and certainly can't plead guilty or not guilty? Again, it wasn't really for the corpse. This was theater, but theater with a very serious purpose. It was for the living audience, the judges, the jury, if there was one, the officials, any spectators, and crucially, the appointed representative. It was a formal declaration for the record, ensuring that the legal process was meticulously followed, at least on paper. It also clearly stated the case the representative had to defend against, however impossible that task might seem. It's like reading someone their rights after they've already left the building permanently. A little late, but technically you did it. Once the accusation was formally entered, the prosecution would present their case. This is where the trial against a dead person really highlights the strangeness. In a normal trial, the accused might offer testimony, call witnesses, provide alibis. A corpse, as you might have guessed, does none of these things. So the evidence presented was entirely from the prosecution side, countered only by whatever arguments the appointed representative could muster. The evidence itself could be varied, reflecting the often less standardized nature of medieval legal proof compared to modern systems. It might include witness testimony from living people who claim to have seen the deceased commit the act or heard them speak treasonous or heretical words. It could involve documentary evidence. Letters, decrees, financial records, though verifying their authenticity, could be challenging. Sometimes physical evidence might be presented, though how useful or well-preserved that would be is debatable. Imagine presenting a supposed murder weapon years after the fact, claiming the deceased used it, with no response possible from the accused. Sina, the prosecutor, might say, holding up a rusty old knife. We submit this as Exhibit A. Any objections from the defense? In. The representative would sigh internally or perhaps outwardly and try to look thoughtful next to their silent client. One of the quirks of evidence in medieval trials, including these, was the reliance on oaths and reputation. The sworn testimony of credible witnesses, especially those of good standing in the community, could carry significant weight. Sometimes the sheer number of witnesses willing to swear to the defendant's guilt was considered powerful evidence in itself. Proof wasn't always about irrefutable physical evidence. It was often about establishing a consensus or convincing the court based on testimony and the overall feel of the case. It's like a popularity contest, but with potentially fatal consequences. Trying to poke holes in this kind of evidence when your client can't tell you their side of the story is difficult. The representative's role here would be crucial and incredibly frustrating. They couldn't ask the corpse, "Hey, remember Tuesday the 14th? Were you really plotting against the king in the market square?" Instead, they would have to rely on examining the prosecution's witnesses, questioning their credibility, pointing out inconsistencies in their stories, or arguing that the evidence, while perhaps suggesting someone did the crime, didn't conclusively prove it was this specific dead person. They might argue that the witnesses were biased or mistaken or just plain lying. It was essentially a trial against the prosecution's narrative, with the corpse serving as a very passive prop. A mainstream historical fact relevant here is that medieval justice systems across Europe often relied on processes that seem alien to us now, such as trial by ordeal or trial by combat, though these were slowly fading or being restricted by the time many corpse trials occurred. However, the concept of divine judgment influencing earthly outcomes, or the idea that truth could be revealed through ritualized processes, lingered. The corpse trial, while not an ordeal in the traditional sense, shared a certain performative, ritualistic quality where the truth was determined through a process that went beyond simple fact-finding. Consider the accusation of heresy a common charge that could lead to a corpse trial, especially if the person had died while under suspicion or after being formally accused. The evidence for heresy often involved proving that the deceased held or propagated beliefs contrary to church doctrine. This could be based on their spoken words, witness testimony writings, if any survived, or even actions deemed heretical. The prosecution would present these proofs to the court, arguing that they demonstrated the deceased's deviation from the true faith. The representative would then have to argue that the words were misinterpreted, the writings were not hers or were taken out of context, or that the actions were not truly heretical. It's a theological debate waged over a body that couldn't possibly care less about doctrine anymore. These trials weren't just theoretical exercises. They had very real consequences, primarily for the deceased's property and family. If the corpse was found guilty, their estate could be confiscated by the crown or the church, leaving their heirs penniless. Their name would be blackened potentially for generations, affecting their family's social standing, marriage prospects, and rights. This is why having even a minimal defense was important. It offered a slim chance of acquittal, thereby protecting the family's interests. The representative wasn't just defending a dead person's soul, they were defending their living descendants' future. It adds a grim practical stakes to the macabre performance. A quirky tidbit about the evidence phase: sometimes evidence presented could include the deceased's own prior actions or reputation while alive. For example, if the person had a history of questioning authorities, secular or religious, or associating with known heretics, that could be presented as evidence supporting the current charges, even if those past actions weren't crimes in themselves. It was a bit like putting the deceased's entire life on trial, viewed through the lens of the specific accusation. See, the prosecutor might argue, he was always asking too many questions about the nature of the Holy Trinity. Clearly, he was a heretic waiting to happen. The representative would then have to argue that intellectual curiosity is not a crime, or that associating with weirdos doesn't automatically make you a weirdo, which is still a valid argument today, frankly. The sheer amount of detail sometimes included in the accusations and the evidence presented could be staggering. Medieval legal documents could be incredibly verbose, listing every alleged offense with excruciating detail. Reading these long, dry documents aloud in court, likely in Latin or the local legal language, must have been a challenge for everyone involved, living or dead. You can almost hear the yawns from the spectators and possibly a faint eternal snore from the defendant. And furthermore, the clerk drones on the third Tuesday of Lent in the year of our Lord, 14XX, the accused was heard saying, "You check your non-existent watch. Are we there yet?" The process of evidence presentation highlights an open scholarly debate. Historians still argue about the true standard of proof required in these corpse trials. Was it the same standard as for a living defendant, or was there a presumption of guilt given that the person was already dead and couldn't defend themselves effectively? Some scholars believe that because the accused was absent in the traditional sense, the deck was inherently stacked against them and convictions were more likely. Others suggest that the very formality of appointing a representative and going through the motions of presenting evidence indicates a desire to maintain some semblance of justice, and that an acquittal, while rare, was possible. It's hard to know for sure without more complete records of these trials and their outcomes. The sensory experience of being in that courtroom during the evidence phase must have been unique. The rustling of parchment, the steady voice of the prosecutor, the attempts by the representative to interject objections or ask clarifying questions, all against the backdrop of a silent, deteriorating body. The air might smell of dust, old paper, and depending on how long the deceased had been deceased, something far less pleasant. The visual is striking the living, breathing participants arguing passionately about the actions of someone who is utterly motionless, whose earthly concerns are supposedly over. It's a potent, slightly sickening blend of bureaucracy and decay. The prosecution would build their case piece by piece, presenting witnesses one after another, reading relevant documents explaining their interpretation of events. The representative's job was to respond to each point as best they could without the benefit of their client's input. They might cross-examine witnesses, trying to trip them up or cast doubt on their testimony. They might argue against the validity of documents or the interpretation of facts. They were essentially shadowboxing, fighting an uphill battle against accusations that their client couldn't refute. It's like playing a video game on hard mode, but your controller is unplugged and the opponent is using cheat codes. Even the most compelling evidence against a living person would feel different when presented against a corpse. There's no gasp of outrage from the defendant, no flush of guilt, no furious denial. Just silence. The prosecution is essentially talking arouse the body, hoping to convince the living members of the court. It's a constant reminder of the fundamental absurdity of the situation, masked by the stern formality of the legal proceedings. The sheer effort involved in gathering and presenting evidence against a dead person also speaks volumes. Why go to all this trouble? It reinforces the idea that the crime was considered extremely serious, perhaps an offense against the state or the church that required a formal legal response even if the perpetrator had died. It shows a deep-seated belief in accountability that extended beyond the grave, or at least the need to perform that belief publicly. It also underscores the potential impact on the living family. Securing the conviction of the corpse was necessary to legally seize their property and assets. So while the trial focused on the dead, the motivations were often very much rooted in the world of the living, particularly wealth and power. The evidence phase could potentially be quite lengthy, depending on the complexity of the charges and the amount of proof the prosecution had gathered. Days might pass with witnesses testifying, documents being read, and the representative trying to make sense of it all, while maintaining a professional distance from their inanimate client. It's a slow, deliberate process designed to build a case stone by stone, even if the foundation it's built upon a dead defendant seems inherently unstable. And all the while, the eyes of the court and any spectators would occasionally flick toward the silent figure at the center of it all, a stark reminder of the bizarre nature of the justice being sought. It's a trial where the defendant offers the ultimate no comment. So the prosecution has laid out their case, reading accusations aloud to a silent, unresponsive defendant, presenting whatever scraps of evidence they could muster from years past, and probably feeling quite pleased with themselves for adhering to protocol, even if the audience included a deceased person. Now it's your turn. As the appointed representative, the attorney for the dead, the advocate for the absence of breath, the spotlight swings, metaphorically speaking, onto you. And you stand there, maybe sweating a little under your robes, looking at your client. Your client isn't just uncooperative. They are fundamentally incapable of cooperation. They offer no notes, no whispered suggestions, no indignant outbursts of innocence, no sudden memories of where they actually were that fateful Tuesday. All they offer is stillness and perhaps a faint odor depending on the specifics of the corpse's state, which certainly doesn't help your case. Your job ostensibly is to mount a defense. But how do you defend someone who cannot speak, cannot be cross-examined, cannot recall events, and whose very presence in the courtroom is a testament to their ultimate irreversible unavailability? It's like trying to win a staring contest against a mannequin, or explaining blockchain to your pet rock. The inherent challenges are less difficult and more metaphysically challenging. You are arguing against a narrative built upon alleged past actions, using only the tools available to you in the present, with zero input from the only person who actually knows the truth or did anyway. Imagine the internal monologue. Right. You might think clearing your throat trying to project confidence. My client, Mr. Ms., a deceased person's name, vehemently denies these charges. You say vehemently denies, but what you mean is incapable of any physical or verbal reaction, including denial, so I'm going to assume they would deny it if they could. It requires a certain level of self-delusion, or at least professional detachment, to maintain this facade. You are arguing on behalf of a legal fiction, a placeholder, for a person who no longer exists in the way the law usually understands existence. The primary strategy available to you is to attack the prosecution's case. Since your client can't provide an alternative narrative or alibi, you must dismantle the one presented by the other side. This means scrutinizing the witnesses. Were they credible? Did they have a motive to lie or exaggerate? Were their memories accurate, especially if the alleged events happened years ago? Medieval testimony, as mentioned before, relied heavily on reputation and oaths. But even reputable people can be mistaken biased or pressured. So you'd likely spend a good chunk of time trying to poke holes in the witnesses' stories. Esteemed witness, you might say addressing someone who claims your client was seen plotting heresy in the marketplace. You state you saw my client on the third Tuesday of Lent. Are you absolutely certain of the date? And from what distance did you observe these alleged actions? Could it have been someone else perhaps wearing a remarkably similar, though tragically non-speaking outfit? You also have to deal with the documentary evidence. If the prosecution presents letters or writings allegedly penned by your client, you could argue they are forgeries or that the words have been misinterpreted or taken out of context. The phrase "down with the crown," you might contend holding up a piece of parchment that looks suspiciously like it's been sitting in a damp basement for decades, could merely express dissatisfaction with a poorly fitting hat, not sedition. My client was known for his sartorial complaints, not political ones. It's a weak argument, sure, but you work with what you've got, which in this case is literally nothing from your client. Another angle is to challenge the interpretation of the alleged crime itself. Was the action truly treasonous or merely critical? Was the belief truly heretical or just slightly unorthodox and perhaps a bit confusing? You could argue that the prosecution has misunderstood the nature of your client's actions or beliefs, framing something innocuous or even pious as criminal. My client's intense interest in the properties of herbs, you might argue in a witchcraft trial, was for medicinal purposes, not spellcasting. She merely smelled strongly of rosemary, not sulfur. You'd have to do this carefully, of course, lest you offend the court with your own potential unorthodoxy. Procedural defense. Did the prosecution follow all the correct legal steps? Was the summoning of the corpse done properly? Was the court the appropriate jurisdiction for this particular charge against the deceased individual? Medieval legal procedures were complex and often very formalistic. Mistakes happen. If you could find a significant procedural error, you might be able to get the case dismissed or at least weakened regardless of the evidence. This is often a lawyer's favorite tactic when the facts are against them. Argue about the paperwork. It's the medieval equivalent of finding a typo on the indictment and demanding the whole thing be thrown out. A mainstream historical fact relevant to this stage is the development of legal representation itself. While the concept of having someone speak on your behalf in court existed in various forms throughout history, the role of professional lawyers or procurators who represented others' interests, especially absent parties, was becoming more formalized in the later Middle Ages. However, the right to legal representation wasn't universal, particularly for those accused of serious crimes like treason or heresy where the state or church was the accuser. The appointment of a representative for a corpse trial wasn't a standard right to counsel. It was a specific legal mechanism often put in place to allow the process, particularly property confiscation, to proceed while maintaining a veneer of due process. So while living defendants might struggle to get good representation, your deceased client was assigned you regardless of your skill or enthusiasm, purely for the sake of legal form. It's the ultimate pro bono case, except maybe you get paid in stale bread or something equally uninspiring. The sheer difficulty of arguing the facts meant that representatives might focus more on arguing points of law or procedure. They might challenge the court's authority to try a dead person at all, a seemingly obvious point to us, but one that the legal system had clearly found ways around. They might argue about the statute of limitations if such concepts applied, suggesting that too much time had passed since the alleged crime. They might even argue about the state of the body. Your Honor, look, my client is clearly incapable of plotting anything. Rigor mortis has set in, although this was likely met with stony silence as the physical state of the client wasn't the point of the trial. One peculiar aspect you might face is the potential for prejudice from the court. While ideally judges are impartial, medieval courts were deeply embedded in the social and political structures of the time. If the deceased was unpopular, or if their property was particularly desirable to the crown or a powerful church official, the court might be predisposed towards a guilty verdict. Your job wasn't just arguing the facts, it was also navigating the unspoken biases of the courtroom. It's like trying to convince a die-hard fan of one sports team that a player from their rival is actually quite talented. Good luck. The silence of your client hangs heavy in the air. Every rustle of your robes, every clearing of your throat, every word you speak feels amplified by the absolute stillness coming from the defense's table. You are a voice shouting into a void, hoping to be heard by the living. The sensory details are unavoidable, the coldness emanating from the body, the potential smell of decomposition masked perhaps imperfectly by incense or herbs strewn in the courtroom, the unnerving visual of arguing at a corpse. It's a performance art piece about the persistence of bureaucracy in the face of biological reality. A quirky or fringe tidbit related to defense tactics. Sometimes the representative might try to argue that the alleged crime was committed before the person's death, and thus the matter should have been dealt with while they were alive. This is a bit of a technicality, as the reason for the corpse trial was often that the person died while accused or before a verdict was reached, preventing a normal trial, and thus leaving their property in legal limbo. But pointing out that the action happened when they were alive highlights the absurdity of trying them. Now, my client was alive when he allegedly did this thing, you might exclaim, gesturing wildly. Surely justice delayed until after death is excessively delayed. The defense might also attempt to introduce witnesses who could speak to the deceased character while alive. Family members, friends, colleagues, or even religious figures might testify to the deceased's piety, loyalty, or general good nature. While this wouldn't directly refute evidence of a specific crime, it could paint a picture of a person unlikely to commit such a heinous act, perhaps swaying the opinions of the court or any jury involved. My client regularly donated to the poor. A witness might declare, hardly the actions of a traitor. What whom? Of course, the prosecution could counter that even saints can fall, or that the charity was a cover for wickedness. Historians still argue whether the appointed representatives genuinely attempted a vigorous defense or simply performed the legal motions necessary for the trial to be considered valid. Some scholars believe that given the overwhelming odds and the potential pressure from powerful accusers, the defense was often a mere formality, a script to be read before the inevitable guilty verdict and confiscation of property. Others argue that the legal system, however strange, valued procedure, and that a representative bound by oath or duty would make a real effort, however futile it might seem to us. There are documented cases where a defense or some procedural issue raised by a representative did lead to an acquittal or the dismissal of charges against the corpse, suggesting that the role wasn't always just theater. But it's hard to gauge intent across centuries based solely on dry legal records. Were they truly fighting or just going through the motions? We may never know their full motivations. The emotional toll on the representative must have been significant. You are arguing for someone who cannot thank you, cannot pay you properly, and whose fate seems sealed by their very condition. You are surrounded by people judging your performance while simultaneously trying a dead body. It's an exercise in professional absurdity, a legal tightrope walk performed over an open grave, metaphorically speaking usually. Every objection you raise feels a little weaker because your client isn't there to back you up. Every point you score against the prosecution feels hollow because, well, you're defending a corpse. It's like being the best lawyer in the world, but your client is a particularly stubborn potato. You might try to evoke sympathy, not for the deceased, who is legally the villain, but for their innocent, surviving family who stand to lose everything if the verdict is guilty. Consider, you might plead, perhaps turning to face the judges or the assembled officials. The plight of the deceased's widow and children who bear no responsibility for these alleged past actions. Should they be stripped of their inheritance, cast into poverty, their name forever tarnished because of charges against someone who is no longer here to defend themselves? This might resonate, tapping into Christian notions of charity and mercy, or perhaps simply appealing to a pragmatic desire not to create more destitute people for the community to support. But it's a long shot. The primary goal of these trials was often that very confiscation. Ultimately, your defense rests on your ability to argue the facts in the law without the fundamental tool of direct communication with your client. You must build your case from external sources, rely on logic and rhetoric, and hope that the court values procedure and fairness enough to genuinely consider your arguments, however outlandish the premise of the trial itself. It's a lonely, bizarre battle against an opponent who isn't even there, fought on behalf of someone who cannot appreciate your efforts. You are quite literally the only thing standing between this body and official damnation and the state seizing their stuff. No pressure. The sheer length of the defense presentation would vary. It could be brief and perfunctory, a quick run-through of formalities. Or if the representative was dedicated or perhaps just enjoyed the sound of their own voice, they might delve into lengthy legal arguments, challenge every piece of evidence, and call their own witnesses, prolonging the strange spectacle. Regardless of length, the core challenge remained: how do you convince people that a dead person is innocent when they can't offer a single word in their own defense? It's a legal paradox embodied in rotting flesh, and you, poor representative, are stuck trying to solve it. You've made your case, argued against a silent client, and thrown every procedural challenge and character witness you could find at the prosecution. The air in the courtroom already thick with tension, and the less than pleasant scent you've tried hard to ignore or perhaps lean into if you're feeling particularly dramatic about the decay of justice, now settles into an expectant hush. The moment of decision has arrived. The judges, or perhaps a jury of peers, depending on the specific legal tradition and era you're navigating, withdraw or deliberate right, their faces grave, probably trying very hard not to look directly at your client on the table. They've heard the accusations, the evidence or lack thereof, your valiant, perhaps desperate defense, and the fundamental, unavoidable fact that the accused is dead. Reaching a verdict in a normal trial involves weighing testimony, assessing credibility, and applying the law to alleged facts. Reaching a verdict in a corpse trial involves all that plus grappling with the metaphysical implications of judging someone who is beyond earthly judgment, at least in the traditional sense. It's like asking a committee to decide if a ghost owes back taxes. The logic of it is just not there from our perspective. But for them, this was a necessary step in a legal process designed to handle specific problems, primarily problems related to property and the state's claim on it. The judges confer. You watch their faces trying to read anything. A flicker of sympathy, a hint of impatience, maybe just indigestion from their midday meal. Your professional future, such as it is, depends on this. More importantly, the future of your client's surviving family, their property and their name hangs in the balance. You've done your best, but your best involved arguing with a body. How effective can that truly be? The possibilities, legally speaking, are too guilty or not guilty. Acquittal is possible, though historically less common in many of these cases, particularly when the alleged crime was serious and involved prominent figures or substantial property. A not guilty verdict means the charges were not proven to the satisfaction of the court. Perhaps your procedural arguments landed, perhaps the evidence was genuinely weak, or perhaps, just perhaps, a judge or jury member felt the sheer absurdity of the situation outweighed the desire for confiscation. If your client is found not guilty, it's a moment of bittersweet, bizarre triumph. The charges are dismissed. The deceased's name, at least legally, is cleared of this specific accusation. Their property, which was likely seized at the beginning of the process, is theoretically returned to their heirs. This is the best case scenario, though it doesn't exactly bring your client back to life for a celebratory feast. The family might breathe a sigh of relief, though they've still endured the trauma of having their loved one's corpse dragged into court. Your reputation as the lawyer who successfully defended a dead person might get a strange boost. You're either a brilliant legal mind or incredibly lucky, probably a bit of both. You managed to convince the court that the potato was innocent. However, the more frequent outcome in high-profile corpse trials, especially those concerning treason, heresy, or other crimes against the state or church, was a guilty verdict. This wasn't necessarily because the evidence was irrefutable, or because the defense was always incompetent, though arguing with a corpse has its limitations. It was often because the trial's purpose was less about determining factual guilt and more about legitimizing the confiscation of property and the posthumous punishment of the perceived offender and their family. The state or church wanted the assets, and a guilty verdict provided the legal justification for seizing them. It was a way to ensure that dying didn't let you off the hook for certain very serious offenses. Oh, you thought you could escape justice by shuffling off this mortal coil? Think again, pal. We'll just try your leftovers. When the court pronounces your client guilty, the sentence is read out. Since the defendant is already deceased, the punishments are necessarily symbolic and aimed at what remains the body, the property, and the reputation. The body might be subjected to further indignities. Depending on the nature of the crime and the local customs, a guilty corpse might be exhumed, if already buried, dragged through the streets, hung burned, or otherwise publicly disgraced. This served as a warning to the living, a gruesome spectacle demonstrating the power of the law, even beyond death. Imagine explaining this to someone today. Yeah, he was found guilty, so they gave his skeleton a stern talking to and then set it on fire. The sheer barbarity of it is jarring, but it was a very real element of medieval justice and punishment designed for maximum public impact and terror. It's the ultimate bad review. Convicted posthumously, 0 stars would not recommend dying before trial. The most significant consequence of a guilty verdict, however, was almost always the confiscation of the deceased property. Lands, wealth, goods, everything the person owned was forfeited to the state, the crown, or the church, depending on who brought the charges. This was often the primary driver behind these trials. Accusing someone of a serious crime that carried the penalty of forfeiture was a swift way for a ruler or institution to acquire valuable assets. The corpse trial allowed them to complete this process even if the accused died before conviction in a regular trial. This had a devastating impact on the surviving family, who were suddenly stripped of their inheritance, potentially left destitute, and their social standing ruined. Beyond property and potential physical indignities to the remains, the deceased's reputation was officially damned. Their name was blackened often for generations. They were branded as traitors, heretics, or criminals in the historical record. This mattered in a society where lineage and reputation were incredibly important. A guilty verdict in a corpse trial cast a shadow not just on the deceased, but on their descendants, potentially impacting their ability to marry, hold office, or participate fully in society. A quirky or fringe tidbit here relates to what happened to the body after a guilty verdict. In some cases of heresy, the body might be burned and the ashes scattered to prevent any possibility of relic veneration or a proper Christian burial. This was not just a physical punishment, it was a theological one, denying the body rest and signaling eternal damnation in the eyes of the church. Imagine the detailed instructions that must have been drawn up for this. Ensure complete combustion, scattering widely, preferably downwind from any villages. It adds another layer of grim absurdity to the proceedings. A mainstream historical fact illustrated by the aftermath of these trials is the concept of attainder. In English law, particularly during the later medieval period and beyond, attainder was the automatic consequence of a conviction for treason or felony. It meant the loss of all civil rights, including the right to inherit or pass on property. The person's blood was considered corrupted, preventing their heirs from inheriting their titles or estates. While the continental European corpse trials might differ in legal specifics, the effect of confiscation and the tarnishing of reputation mirrored the consequences of attainder. The corpse trial was essentially a way to apply the consequences of attainder even when the person had died before a living conviction. It was a legal workaround to ensure the crown got its hands on the deceased traitor's stuff. The sentence might also include symbolic punishments against the deceased's effigy or coat of arms. These might be defaced or destroyed, further emphasizing the posthumous disgrace. If the deceased held titles, they were stripped away. It was a comprehensive attempt to erase the person's positive legacy and status, replacing it with a permanent mark of shame. Your job, if the verdict is guilty, is now officially over, and it feels like you just spent weeks arguing with a particularly stubborn mannequin for absolutely no positive outcome for your client or their family. You might get paid maybe if there's anything left after the confiscation, which is doubtful. Historians still argue whether the primary motivation behind most corpse trials was genuinely about administering justice and deterring crime, or if they were predominantly driven by the desire to confiscate property. While the legal frameworks emphasize the former, that a person should face judgment regardless of death, the frequency with which wealthy or politically significant individuals were targeted and the invariable outcome of property seizure in guilty verdicts strongly suggests economic and political motives were paramount. Were they upholding abstract principles of law or just finding a legally sanctioned way to loot dead people's estates? It's a classic debate about the interplay of power law and economics in history. Consider the sensory details of the aftermath. If the body is subjected to public punishment, you might witness the grisly spectacle. The smell of smoke from a burning pyre, the jeering of a crowd watching a corpse dragged through the mud, the chilling silence of a formerly grand house, now empty and sealed, waiting for royal officials to inventory its contents. These aren't just legal outcomes. They are public events designed to instill fear and demonstrate authority. You, the representative, might stand on the sidelines, perhaps trying to blend into the crowd, reflecting on the bizarre case you just handled. Even in cases of acquittal, the process itself left a scar. The family had to live through the public accusation and trial. The body, having been exhumed and put on display, might require reburial. The whole affair was a traumatic disruption of the grieving process. The legal system, in its strange pursuit of posthumous accountability, inflicted a very real, very painful ordeal on the living. One final, slightly dark joke thought, if your client was found guilty and burned, does that count as cremation? Was the medieval legal system inadvertently pioneers of the modern funeral practice, just with less consent and more public humiliation? Probably not. The end result of a corpse trial, whether guilty or not guilty, highlights the unique position of the deceased in the legal system. They were not truly defendants in the modern sense capable of participating in their defense. They were objects upon which legal procedures were performed primarily to determine the fate of their property and legacy. The trial wasn't for them, it was for the living, for the state to assert its power, for the church to assert its authority, for potential rebels or heretics to see their fate, and for families to either reclaim their status or be ruined. The verdict delivered, the sentence pronounced, the courtroom begins to disperse. The judges leave, the clerks gather their papers, and the onlookers file out, perhaps discussing the strange spectacle they just witnessed. You are left standing there, possibly next to the table, where your former client lies, a silent, inanimate testament to the strangeness of medieval law. Your role is complete. The outcome is final, at least in the earthly realm. What happens to your client's soul, of course, was an entirely separate matter left to divine judgment. Though a guilty verdict in an earthly court might not bode well for their chances in the celestial one, according to the beliefs of the time. You pack your papers, perhaps carefully avoiding eye contact with the bailiffs preparing to handle the body, according to the court's decree. You've navigated the rapids of the medieval legal system, defended a corpse, and witnessed the peculiar intersection of law, death, and property rights. It's probably not the case you'll be bragging about down at the tavern, unless you enjoy baffled silence. Yeah, I had a tough one this week. Client was unresponsive. Verdict was messy. The legacy of these trials is complex. They show a legal system grappling with death's disruption, finding ways to extend jurisdiction beyond the grave for practical ends. They also reveal a society where status, property, and public order were paramount, and where even death offered no guaranteed escape from earthly judgment and its consequences for the living. You step out of the courtroom, leaving the body and its fate behind, probably just wanting to get home and wash the lingering scent of formaldehyde alternative and existential dread off your robes. The gavel falls one final time, the verdict delivered, like a death knell, for hope echoing in the cavernous courtroom long after the sound physically fades. If your client was found guilty, the sadly more common outcome for those whose assets made them targets, your job as defender is done, but the consequences for the living are just beginning. You watch the officials move towards the table where the body lies, their purpose grim and dictated by the court's sentence, but your gaze drifts past them towards the back of the room where the deceased family likely sits. Their faces are pale, devastated. They came hoping against hope that arguing against a corpse could somehow save them, and now they face ruin. The immediate and often most devastating consequence of a guilty verdict was the confiscation of all the deceased property. This wasn't just a technical legal term. It meant everything the person owned was now forfeit to the authority that brought the charges, usually the crown, a powerful noble, or the church. Imagine their home, your client's home, being seized. Officials would arrive perhaps the very next day with formal papers and stern faces. They would inventory everything: the furniture you or your client sat on, the tapestries on the walls, the clothes in the chests, the livestock in the fields, the tools in the workshop, the jewels, the money, the very ground the house stood on. It was all taken. The family, the spouse, children, elderly parents, siblings, were essentially dispossessed. They might be given a short time to gather a few personal belongings, maybe just the clothes on their back, before being forced out. Their home, the source of their security and identity, was no longer theirs. It was now state property or church property, or the property of the Lord who had accused their deceased relative. You can almost feel the cold dread settling over you as you imagine this scene playing out. The bewildered children watching strangers carry away their toys, the wife clutching a small bundle of necessities, the officials methodically listing assets, perhaps arguing over the value of a silver goblet or a particularly fine horse. Right, list this fancy chair. Looks uncomfortable, but probably worth a few shillings. Don't forget the dust bunnies under the bed. They're technically part of the estate. Maybe this property confiscation wasn't just about getting rich, though that was a definite perk for the authorities. It was a fundamental aspect of medieval justice for serious crimes, particularly treason and heresy. These crimes were seen as offenses not just against an individual, but against the entire social and political order, or against God himself. Dying didn't erase the crime or its consequences, especially when those consequences involved striking at the very foundations of the deceased's power and influence, which was often tied directly to their wealth and land. The corpse trial was the legal mechanism to achieve this state objective when death intervened. The impact on the deceased's heirs was profound and often irreparable. In many legal systems, particularly in England, conviction for treason or felony resulted in attainder, a legal state where the convicted person lost all civil rights, including the right to inherit or pass on property. Their blood was considered corrupted, meaning their children could not inherit their title or estates. While the specific terminology might differ on the continent, the effect was similar for the families of those convicted posthumously in corpse trials. They didn't just lose their immediate inheritance, they lost their birthright, their social standing, and often their future prospects. Imagine being born into a noble family destined to inherit lands and titles with a clear path laid out for you. Then your father is tried and convicted. After his death, his name blackened, his corpse perhaps publicly disgraced. Suddenly your entire world shatters. You are stripped of your inheritance, your title is gone. Your family name is synonymous with shame and treachery. Your social circle evaporates. Potential spouses from respectable families are no longer interested. Your career options are severely limited. You are through no fault of your own except having the wrong parent, effectively a non-person in the eyes of the law and society. It's like being canceled medieval style, but the stakes are much higher than just losing your social media followers. The authorities weren't always complete monsters. Sometimes a small allowance might be made for the support of the spouse or young children, particularly if the crime wasn't high treason or if there was some political expediency in showing a sliver of mercy. But this was the exception, not the rule, and certainly not guaranteed. The primary goal was often to dismantle the deceased's power base and ensure their lineage didn't pose a threat or retain undue influence based on ill-gotten, in the court's eyes, gains. A quirky or fringe tidbit regarding the aftermath concerns the detailed inventories sometimes taken of the confiscated property. These weren't just dry lists of land deeds and coin counts. They could include incredibly specific items down to individual spoons bedding or even religious artifacts. Reading these inventories today offers a fascinating, if grim, glimpse into the daily lives and possessions of medieval people, cataloged only because their owner met a tragic, posthumous legal end. You might find a list detailing one worn velvet cloak, 3 silver salt cellars, a small box of bone dice, and one rather lumpy mattress. It's a bizarre snapshot of domestic life captured at the moment it was ripped apart by legal process. Imagine being the clerk whose job it was to list everything. Okay, that's 17 chickens, a slightly chipped chamber pot, and what appears to be a very old piece of cheese glued to the floorboards. Do I list the cheese? This process also highlights a mainstream historical fact. The power of the state, or dominant authority in the medieval period, was increasingly tied to its ability to enforce laws and extract resources, often through mechanisms like forfeiture. These trials weren't just about abstract justice. They were tools of governance, allowing rulers to consolidate wealth, punish political enemies even after death, and send a clear message to the living about the consequences of defying authority. Confiscated property could fund wars, build castles, or enrich loyal supporters, making these posthumous convictions very attractive to those in power. It was a form of involuntary wealth redistribution from the accused's family to the ruling elite. For the surviving family, the immediate future was bleak. They might be forced to rely on the charity of more distant relatives, if any were willing to associate with a tainted family or the church. Many faced poverty, forced to take on menial labor if they were capable, a stark contrast to their former lives of privilege. Their social standing plummeted. They were now the family of a convicted traitor or heretic, a stigma that would follow them and potentially their descendants for generations. It wasn't just financial ruin, it was social obliteration. Historians still argue whether the severity of punishment against the family was primarily intended as part of the deterrent against future crimes, or if it was simply a necessary side effect of targeting the deceased's wealth. Were the authorities deliberately trying to make an example of the family to scare others, or were they just focused on seizing the assets and the family's suffering was secondary? The truth is likely a blend of both. The ruin of the family served as a potent warning, demonstrating that even death offered no complete protection for your legacy or loved ones if you crossed the line. There were rare instances, sometimes generations later, where a family might petition a subsequent ruler or authority to have the attainder reversed or the confiscated property returned. This often required significant political maneuvering, large sums of money if they had managed to squirrel any away, or had supportive relatives and favorable political conditions. It was a long, arduous process with no guarantee of success, but the desperate hope of restoring their family's name and fortune drove some to try. Imagine spending decades trying to get your ancestral home back, only to find it's been turned into a particularly depressing tax office. The courtroom is empty now, the echoes of the verdict replaced by the sounds of daily life resuming outside. You step out, leaving the peculiar spectacle behind. The body will be dealt with according to the sentence, perhaps taken for public display and punishment, or perhaps simply carted off for a less than respectful burial. The family, if they were present, is gone, dispersed to face their grim reality. Your involvement in this particular bizarre case is over. You defended a literal non-responsive client against charges that couldn't truly touch them, only to see their loved ones bear the brunt of the punishment. It's a harsh lesson in how medieval law could twist logic and bypass the individual to target wealth and status. You might walk home feeling a deep sense of futility. All your legal skill, your arguments, your knowledge of procedure. Ultimately, they couldn't save this family from the state's reach extended beyond the grave. You probably need a strong drink or perhaps a long hot bath to wash off the metaphorical stench of legal decay and actual courtroom smells. Your fee, if you were representing the family and not appointed by the court, might never materialize because, well, there's no property left to pay you with. Payment. Oh, about that, the king took the strongbox. Sorry, here have this slightly used handkerchief. The family's plight underscores the brutal efficiency with which medieval states could assert their power and control resources. It wasn't a system big on safety nets or consideration for innocent relatives when faced with what they deemed fundamental threats to order or belief. The legacy of a corpse trial wasn't just a historical footnote about weird legal procedures. It was a lived trauma for generations of families who bore the name and the shame of the posthumously convicted. Their story, the story of those left behind, is a crucial part of understanding why these trials happen and who they truly impacted. And with that, you head home, the weight of the day's absurdity heavy on your shoulders, the image of a family's ruined faces etched in your mind. You defended the dead, but it was the living who paid the price. The heavy oak door swings shut behind you, muffling the sounds of the court officials beginning the grim work inside. Your feet crunch on the cobblestones as you step out into the bustling medieval street, the air thick with the smells of horse manure, baking bread, and something suspiciously like cabbage. The trial is over, the verdict delivered, the future of the deceased family tragically sealed. But while their fate is one kind of punishment, the body itself is about to endure another, often far more public and gruesome ordeal, dictated by the specifics of the sentence. You see, a guilty verdict in a corpse trial wasn't usually just about asset forfeiture and family ruin. For serious crimes like treason or heresy, the punishment was meant to extend beyond the grave, targeting not just the deceased's earthly possessions, but also their reputation, their memory, and even in the beliefs of the time, their spiritual well-being. The body, which was the physical representation of the person who committed the crime, became a symbolic vehicle for society's condemnation. It needed to be dealt with not with the usual rites for the dead, but with deliberate dishonor. If the person had already been buried, the first step might be exhumation. Imagine this scene a few days or weeks after the trial officials arrive at the churchyard. Armed with shovels and orders from the court, they proceed to dig up the grave. The gravedigger, likely paid extra for this unpleasant task, works under the watchful eyes of a bailiff or priest. It's a grisly business, unsettling even for people used to death. The smell would be considerable. As the spade hits wood, a collective grimace might pass through the small crowd that inevitably gathers to witness such an event. Right shift that bit of soil. Careful not to chip the coffin, we still need it for the display. Once unearthed, the coffin, or sometimes just the body itself, if the coffin had deteriorated, would be transported. This wasn't a respectful procession. Often the body was dragged through the streets, perhaps tied to a horse's tail, or pulled on a makeshift sledge. It was a public spectacle of shame and degradation. You might be walking down the street minding your own business, perhaps haggling over the price of a chicken, when suddenly the crowd parts and you see this macabre procession approaching. The deceased, who might have been a respected figure in life, is now reduced to an object of scorn and pity, bumping along the rough ground, becoming covered in mud and refuse. The destination for this grim journey was usually a public place of execution or punishment. The town square, the gallows hill, outside the city walls, or perhaps just a prominent crossroads. Here, the ultimate physical punishment would be meted out to the corpse. The specifics depended heavily on the crime and the local customs, but common punishments included hanging, burning, or even decapitation or dismemberment, echoing the punishments prescribed for the living. For treason, the body of the convicted traitor might be hanged just as they would have been if caught alive. But since they were already dead, this was a symbolic act. Hanging the lifeless form served as a powerful visual warning to the living. Sometimes the body would be left hanging for days or weeks, a decaying testament to the consequences of disloyalty. You can picture the scene, a lonely figure swaying in the breeze on the gallows, not breathing, not struggling, just a stark, silent message nailed against the sky. Passers-by would avert their eyes, perhaps mutter a prayer, or maybe just hurry along, trying not to think about it too much. The local birds, however, were probably thrilled. Free lunch. If the crime was heresy, the punishment often involved fire. Heresy was seen as a corruption of the soul, a spiritual poison, and fire was considered a purifying element capable of cleansing or utterly destroying the tainted matter. So the body of a convicted heretic, even if already dead, might be burned at the stake. The scene at the stake was usually a chaotic, horrifying affair, but for a corpse, it would be a quieter, albeit equally gruesome spectacle. The body would be tied to the stake the pyre built and then ignited. The smell of burning flesh, already familiar from executions of the living, would fill the air mixed with the scent of burning wood and perhaps tar. These acts weren't just random acts of violence. They were deeply symbolic rituals. Hanging the traitor's body inverted the natural order of a respectful burial, denying them rest and peace. Burning the heretic's body aimed to destroy the physical vessel of their perceived spiritual corruption, preventing its pollution of the earth, or denying it the possibility of resurrection, according to some interpretations. The public nature ensured the message was received loud and clear: defy the authorities or the church, and the consequences will follow you even beyond the grave. A mainstream historical fact here is that post-mortem punishments, particularly hanging for treason and burning for heresy, were standard judicial practices across medieval Europe for those crimes whether the person was alive at the time of conviction or not. Dying before trial didn't grant immunity. It just changed the timing and the means of the punishment. It underscores how seriously these societies viewed threats to their core political and religious structures, to the extent that they felt compelled to inflict physical suffering and dishonor on a corpse. It wasn't just about vengeance. It was about maintaining order through terror and symbolic purification. A quirky or fringe tidbit relates to the logistics of punishing a corpse, especially if it had been buried for a while. Imagine the state of a body that's been in the ground for months or even years, like in the infamous Pope Formosus case, which we might touch on later, maybe if you're not too sleepy. It wasn't exactly in display condition. Sometimes efforts were made to prop the body up, dress it, or otherwise make it identifiable for the public spectacle, even if it was just a skeletal remains. Other times, they might just drag out a box of bones. The executioners and officials responsible must have had a truly terrible time dealing with these decaying remains. It wasn't the clean, albeit brutal work of executing a living person. It was gross, messy, and probably smelled awful. Right, whose turn is it to reattach that arm it keeps falling off? Historians still argue whether the primary purpose of these physical punishments was to inflict further suffering on the corpse itself, viewed as a form of lingering identity to maximize the public spectacle and deterrence for the living, or to spiritually condemn the deceased by denying them proper burial rites. Was the medieval mind truly convinced the corpse felt something, or was it solely about the message sent to the community? Most likely it was a complex blend of all three motivations, reflecting a worldview where the physical body, the social standing, and the spiritual state were deeply intertwined, even in death. The impact of these public displays on the community was significant. These weren't abstract legal proceedings. They were visceral public performances designed to reinforce power structures. Seeing the body of a former neighbor, friend, or leader subjected to such indignities was a stark reminder of the authorities' absolute power. It instilled fear and discouraged dissent. Children were probably shielded or warned away, but they would still see the gallows, the burned stake, the bodies left hanging. It was a regular, albeit infrequent, part of the urban landscape. Sometimes the punishment went beyond just hanging or burning. Depending on the severity of the crime, particularly treason, the body might be mutilated. This is where it gets tricky to stay PG-13, but let's just say parts of the body might be removed and displayed in different locations as further warnings. A head on a spike above the city gate, for example. While primarily associated with executions of the living, these acts of dismemberment could also be applied to corpses after a posthumous conviction, amplifying the dishonor and the widespread nature of the deterrent. Imagine walking through the city gate and seeing, well, you get the picture. Not exactly a welcoming sight. The fate of the body after the initial punishment varied. It might be left on display until it decomposed or was removed by birds and weather. More often, after a period of public viewing, it would be disposed of in a manner equally devoid of respect. This meant burial in unconsecrated ground. Outside the churchyard, perhaps at a crossroads, a common burial place for criminals and suicides, or simply in a ditch. This was another layer of spiritual punishment, denying the deceased the rest and sanctity of a proper Christian burial. Their body would not lie in holy ground awaiting the resurrection among the faithful. Instead, it would be cast out just as their soul was believed to be. For the surviving family members, the agony didn't end with the confiscation of their property. They also had to live with the knowledge of their loved one's body being subjected to such humiliation. They couldn't give them a proper funeral, they couldn't visit their grave in a hallowed place. Their relative's final resting place was a site of shame, if it existed at all. This was a profound source of grief and further social stigma. It was the final indelible stain on the family name etched into the very earth itself. Remember where Old Man Fitzwilliam is buried? Yeah, don't go near that ditch. The practicalities of these punishments are also worth a moment's thought. Who paid for the digging, the dragging, the wood for the pyre, the rope for the gallows? Presumably, these costs were borne by the same authority that profited from the confiscation of the deceased's assets. It was, in a twisted sense, self-funding justice. The dead paid for their own final ignominious spectacle with the wealth they left behind. This physical desecration of the corpse after a trial is perhaps the most visually striking and disturbing aspect of medieval corpse trials. It reveals a legal and social system that saw the human person not just as an individual entity ending at death, but as part of a larger continuum of family property and reputation, all subject to the state's power and the church's authority. The body was the last remaining piece of the convicted individual, and its treatment was a final emphatic statement of condemnation that resonated far beyond the life it had housed. As you walk away from the courtroom area, heading back to your own, hopefully more normal life, the image of the potential indignities awaiting the body hangs in your mind. It adds another layer to the strangeness of the case you just witnessed. You defended someone who couldn't speak only for their property to be seized, and their physical remains subjected to punishments that couldn't harm them, but caused immense pain and shame to the living. It's a peculiar kind of justice indeed. You might pass the gallows on your way home, give it a wide berth, and be profoundly grateful that for now at least your own body is still firmly attached to your soul, and that your potential legal troubles are strictly confined to the living. You walk away from the courtroom, the sounds of the town square washing over you, but the chill of the proceedings still lingers. The fate of the deceased's body is sealed. Dishonor, public spectacle, perhaps even physical destruction, as we just contemplated. It's a grim thought, undeniably. But for the living people connected to that corpse, the punishment is just beginning, and arguably it's far more devastating in its long-term consequences. Because a guilty verdict in a medieval corpse trial wasn't just about disgracing the dead, it was about utterly ruining the lives of their surviving family. Imagine this: the final pronouncement echoes in the courtroom. Guilty, the crowd murmurs. And just like that, everything changes for the spouse, the children, perhaps even extended family members who relied on the deceased. The most immediate and crippling consequence was the forfeiture of all assets. This wasn't just a fine. This was complete and total confiscation. Every acre of land, every building, every piece of furniture, every tool, every last coin. It all went to the crown, the local lord, or whoever had prosecuted the case. Think about what that means. You wake up one morning, perhaps a few days after your father or husband died, mourning his loss. You attend his trial, hoping for vindication, maybe thinking about sorting through his affairs, and then bam, he's declared guilty posthumously, and suddenly you own nothing. The roof over your head, not yours anymore. The fields that feed your family, gone. The stock of grain in the larder, confiscated. Your horse, your cow, the very clothes on your back, well, maybe not those, but close, all subject to seizure. This legal process was often referred to as attainder. It essentially meant that the person was attainted or stained with the crime, and this stain extended to their property and to some degree their bloodline. Forfeiture was a standard punishment for serious crimes like treason or felony committed by the living, but applying it to the dead felt particularly cruel because the person who earned the punishment was beyond suffering its earthly effects, while their innocent family bore the full brunt of the financial ruin. So picture the scene: officials arrive at the family home. They have a list. They go room by room, barn by barn, field by field, documenting everything. Right, that chest of linens that's on the list. The plow in the barn, yep, got it. 3 cows make that 0 cows now, I'm afraid. You and your children are standing there watching your entire world being cataloged and taken away. There's nothing you can do. There's no arguing. The law has spoken even if the person it judged is no longer around to hear it. It's like a really aggressive probate process where instead of getting grandma's slightly too loud cuckoo clock, you lose everything, including the kitchen sink. If you even had a kitchen sink, where do you go? What do you eat? If you were a peasant farmer, your land is gone, your tools are gone, your livestock is gone. If you were a merchant, your shop, your goods, your capital, all seized. If you were a noble, your castle, your estates, your titles, often, titles could also be forfeit. Though that's a slightly different legal concept, it compounds the ruin. You are left with literally nothing but the clothes you are wearing, maybe a few small personal items if you were lucky, and they weren't deemed valuable enough to bother with. You've gone from a respected or at least self-sufficient member of the community to an indigent beggar overnight. The social impact was equally brutal. You weren't just poor, you were the family of a convicted criminal, a traitor, or a heretic. In medieval society, reputation and social standing were everything. Your family name was now mud. People would avoid you. Merchants might refuse to trade with you. Neighbors who were once friendly might cross the street to avoid you. Your children might be ostracized at church or school. Finding new work would be incredibly difficult. Who wants to employ the offspring of someone legally declared a disgrace, even after death? This wasn't just temporary awkwardness. It could be a multi-generational curse. The stain on the family name could make it hard for children to marry well, to inherit property from other relatives, as they might be viewed with suspicion or to rise in any profession. Historians still argue whether the intention was purely economic confiscation or whether there was a deliberate aim to permanently incapacitate the family and prevent any future resurgence that might challenge authority. Was it just about grabbing wealth, or was it also about breaking the lineage of perceived troublemakers? It was likely a mix depending on the severity of the crime and the ruthlessness of the authorities. The shame was compounded by the public treatment of the body, which we discussed last time. Imagine trying to maintain any shred of dignity when your husband's body is hanging on the gallows or your father's bones are being dragged through the street. Every public humiliation of the corpse was a fresh wound for the family, a visible, undeniable symbol of their disgrace. People wouldn't just whisper about the dead person. They would see the spectacle and connect it directly to the grieving survivors. Oh, look, there's the widow of that guy whose body is currently decorating the town square. Awkward. A mainstream historical fact is that the principle of forfeiture for serious crimes, felony and treason, was well established in medieval law across Europe. What makes the corpse trial application particularly notable is that it extended this punishment beyond the point where the individual could face earthly justice themselves, ensuring the state didn't lose out on the financial penalties just because the accused inconveniently died. It was a way for the law to maintain its reach, ensuring that death did not become a loophole for escaping the financial and social consequences of perceived guilt. A quirky or fringe tidbit might involve the specific fates of minor family members or servants. What happened to the elderly mother living with the family or the loyal household staff? Were they simply turned out onto the streets along with everyone else? Sometimes specific provisions or petitions might be made, particularly if the family had powerful connections. But more often than not, their fate was tied to the main household, and they were left just as destitute. Imagine being a servant who had worked for the family for 30 years, only to be sacked without a penny because your dead boss was convicted of something he couldn't even defend himself against. Tough break. The church's role here is interesting too, and not always straightforward. While the state enforced the forfeiture and public shame, the church often condemned usury and excessive wealth, but rarely intervened to protect families from legal confiscation, especially in cases of heresy, which the church itself often prosecuted. Sometimes, however, local charities or monastic orders might offer some limited relief to destitute families, though this was charity, not a right, and often came with its own layers of social stigma. The family was left entirely reliant on the mercy of others, a harsh fall for anyone of any standing. There was virtually no recourse for the family. They couldn't appeal the verdict against the deceased. They couldn't petition for the return of their property, at least not successfully, unless the original verdict was somehow overturned much later, which was exceedingly rare. Their lives were irrevocably changed, shattered by a trial where the accused was silent and absent. The law in this instance wasn't a protector. It was a destroyer visiting the sins of the dead upon the living with chilling efficiency. Consider the psychological toll. Beyond the grief of losing a family member, they faced homelessness, starvation, social isolation, and the constant grinding anxiety of survival. They had to live with the knowledge that their loved one was officially labeled a criminal and their memory publicly disgraced. It was a continuous living punishment that far outlasted the physical indignities inflicted on the corpse. Sometimes in cases of high treason, the severity of the punishment could be mind-boggling. Not only was property confiscated, but certain rights could be stripped away from descendants for generations. While the concept of outright corruption of blood, preventing future inheritance from anyone, eventually waned, the practical effects of ruin and social stigma often served a similar purpose, limiting opportunities and keeping the family down. It was a system designed in part to ensure that families of those who threatened the established order could not easily recover and pose a threat in the future. The records of medieval courts are full of property inventories taken after such convictions. They list everything from manor houses and vast tracts of land to humble cottages, simple tools, cooking pots, and worn clothing. Reading these lists gives you a tangible sense of what was lost, item by item. The entire fabric of a family's life systematically dismantled by legal decree. One iron pot valued at 6 pence. Item 2 blankets valued at 1 shilling. Item 1 milking cow valued at 5 shillings. All forfeit to the king. Heartbreakingly mundane details that represent utter catastrophe for those left behind. The families were essentially collateral damage in the state's assertion of power and the church's enforcement of doctrine. Their ruin served as a potent deterrent to the living, a clear message that aligning yourself with perceived enemies of the state or faith carried risks that would reach far beyond your own lifetime. You might die before they catch you, but your family would pay the price. It added an extra layer of fear to simply existing in a society with such unforgiving laws. As you continue your walk through the bustling medieval town, the smells and sounds bring you back to the present, such as it is. The baker's pulling fresh loaves from his oven, smelling wonderful. A blacksmith hammers rhythmically in his forge. People are laughing and haggling in the market square. It's easy to forget the darker undercurrents of this world, the harsh realities of justice and punishment that could shatter lives so completely. But the memory of the courtroom, the verdict, and the thought of that family being stripped bare because of a dead relative's alleged actions lingers. You pass a woman holding out her hand asking for alms. She looks worn down, her clothes are threadbare, her eyes seem to carry a heavy sadness. Is she just poor, or is she perhaps one of the unlucky ones, a survivor of a similar legal catastrophe, living proof of the devastating aftermath of a corpse trial? You wouldn't know just by looking. The scars of such events weren't always visible, but they ran deep, affecting not just the finances, but the very identity and future of the family. It's a stark reminder that in the medieval world, justice was often less about individual rights or rehabilitation, and more about maintaining social order, asserting authority, and often generating revenue for the powerful. And the dead, along with their living kin, were simply instruments in that system. You try not to dwell on it too much, focusing instead on finding somewhere to get a decent, uncontested meal. Maybe something with lots of bread. Okay, take a deep breath. You've walked away from the courtroom, away from the chilling images of the body's fate and the devastating reality for the family, but your mind keeps circling back to the central, perplexing question. Why? Why go through all this rigmarole for someone who is already dead? From our modern perspective, it seems utterly nonsensical. The person is gone. They can't feel pain. They can't be rehabilitated. They can't serve time. They can't pay a fine, though their family can, as we've just seen. So what on earth was the point of putting a corpse on trial? To understand this, you have to try and step inside the medieval mind, and particularly the medieval legal mind. It wasn't just about prosecuting a person. It was about prosecuting a crime of renown, about restoring social and cosmic order, and about dealing with the very sticky problem of death interfering with earthly justice. Medieval people, of course, had a profoundly different relationship with death than many of us do today. Death wasn't seen as a final absolute end, where everything about the person ceased to matter on earth. The soul went on, certainly, but the body remained a physical vessel that had housed the individual and was still in some ways intrinsically linked to their earthly identity and actions. There was also a strong belief that earthly actions, especially serious sins or crimes, had consequences that extended beyond the grave, not just for the soul in the afterlife, but for the community left behind. An unpunished crime, particularly heresy or treason, against a divinely appointed ruler, was seen as a stain on the community, potentially even risking divine displeasure. So the law felt it had a duty to address these serious matters, even if the perpetrator had slipped away via natural causes. Death wasn't a get-out-of-jail-free card for major offenses. One of the primary legal justifications for trying a corpse revolved around the concept of contumacy. This is a fancy legal term that basically means refusal to appear in court when summoned. In medieval law, if you were accused of a serious crime and failed to show up for your trial, you could be declared guilty by default, or at least put through a trial in absentia, where the deck was heavily stacked against you because you weren't there to defend yourself. Your property could be seized and you might be outlawed. Now apply this to a dead person. They are by definition absent from court. They cannot respond to the summons. Therefore, in the eyes of some medieval jurists, their absence could be interpreted as a deliberate refusal to appear. Contumacy. It sounds ridiculous, doesn't it? Your Honor, the defendant refuses to answer the charge, but he's dead. Contumacy guilty. It was a legal fiction, certainly, but a convenient one that allowed the process to move forward. Historians still argue whether this was a genuine extension of legal principle or primarily a convenient excuse to confiscate property and assert authority. Was the legal reasoning sincere, or was it a smokescreen for political and financial gain? Probably a bit of both, depending on the specific case and era. The dead person was often represented in court, sometimes by a proxy, or even just by their corpse or effigy, as we'll see, but they couldn't actively participate in their defense. Any advocate appointed was often in a difficult position, essentially defending the memory and actions of someone who couldn't provide instructions or contradict witnesses. The deck was stacked sky high against the defendant. Imagine being that poor lawyer. My client pleads. Well, my client doesn't plead anything. He's been dead for 3 months, but I assure you, if he could plead, he'd plead not guilty. Another angle was the idea that the crime itself, rather than just the person, needed to be judged and punished. A heresy wasn't just a thought in someone's head. It was an offense against God and the church, a harmful contagion that needed to be publicly identified and condemned. Treason wasn't just disloyalty. It was a betrayal of the social contract and the natural order. These acts left a sort of spiritual and legal residue that needed to be cleansed through formal process. The trial of the corpse was a ritualistic act, a public declaration that this specific act was indeed criminal, even if the perpetrator had escaped earthly punishment through death. There was also the aspect of setting a precedent and a warning. If someone could commit high treason or flagrant heresy and simply die peacefully in their bed, avoiding all legal consequences, it might encourage others. Trying and punishing the corpse and ruining the family sent a very clear message to the living. You cannot escape justice just by dying. The law will find you, or at least what's left of you, and make an example. It was a powerful deterrent, perhaps even more terrifying than punishment of the living, because it showed the state's reach extended even into the realm of the deceased. The medieval legal system also intertwined earthly law with divine law. While God would ultimately judge the sole earthly authorities, particularly the church in cases of heresy, felt they had a duty to identify and condemn actions deemed criminal or sinful in this life. A corpse trial could be seen as a necessary step in the earthly realm before the final divine judgment. By declaring someone a heretic or traitor on earth, you were in a sense aligning earthly judgment with what was presumed to be God's judgment, or at least formally recognizing the gravity of the offense before God. It was a way for the earthly powers to affirm their authority and their role as enforcers of both human and divine order. What about the confession after death part mentioned in the outline? This is where things get particularly strange. In some legal systems, confession was highly valued, seen as both proof of guilt and a step towards potential redemption, even if earthly punishment still followed. Obviously, a corpse cannot confess, So how was this handled? Sometimes the evidence of guilt was interpreted from the state of the body or circumstances of death, though this is less common in formal corpse trials and more in folk belief or trials by ordeal. For instance, in some folk beliefs, though, less formal legal practice, a corpse that bled in the presence of the suspected killer was taken as a sign from God. While formal corpse trials didn't rely on such supernatural tests, they did rely heavily on evidence gathered before or immediately after death. Witnesses would testify to the actions of the deceased while they were alive. Letters, documents, or other evidence of the crime would be presented. The trial itself was less about discovering new evidence or getting a confession from the dead, and more about formally presenting the existing evidence and reaching a legal verdict against the deceased or a persona represented by the corpse based on their life's actions. Perhaps the confession after death phrase in the outline bullet was slightly misleading. It wasn't about the corpse confessing, but about the process acting as a form of posthumous judgment that in a medieval mindset might somehow bear upon the deceased's standing or legacy. Or perhaps it referred to cases where the deceased had confessed before dying, but the trial was still held to formalize the conviction and enact the consequences like forfeiture. A mainstream historical fact here is that medieval legal thought, particularly influenced by Roman law principles and canon law church law, placed great emphasis on the concept of status and reputation. A trial wasn't just about punishment, it was about formally changing a person's status in the eyes of the law and society. Being declared a traitor or heretic wasn't just a label. It had profound legal consequences like the attainder we discussed, which stripped away rights and property. Trying the corpse ensured that this change in status happened formally, publicly, and legally cementing the person's posthumous reputation as a criminal and justifying the actions taken against their memory, property, and family. Think of it as reputation management, but in reverse and with extreme prejudice. You wouldn't want the community remembering Lord so-and-so as a noble figure if he'd secretly plotted treason, right? The trial corrected the historical record, so to speak, ensuring his memory was officially tainted. It's like a posthumous cancellation on a truly epic scale with actual legal and financial consequences, rather than just getting ratioed on Twitter. A quirky or fringe tidbit related to this legal logic involves the treatment of animals in medieval courts. Yes, medieval courts sometimes tried animals for crimes. The legal arguments used were often similar. The animal was treated as if it had acted with intent, and its failure to appear or defend itself could be interpreted as contumacy. The logic applied to animals shared some roots with the logic applied to corpses, attributing legal responsibility and agency where we would see none, all in the service of upholding a perceived legal and social order. It highlights just how differently medieval people viewed the boundaries between human, animal, and even inanimate objects in the context of legal accountability. Your pig could literally face trial for murder if it attacked and killed someone. Don't laugh, it happened. So the weird logic boiled down to a combination of factors. 1. A different understanding of death where the deceased's earthly actions still mattered to the living community and the legal system. 2. The adaptation of legal principles like contumacy to justify proceeding against an absent dead defendant. 3. The perceived need to formally condemn serious crimes to maintain social, legal, and spiritual order. 4. The importance of posthumous reputation and the legal necessity of stripping it away for serious offenders. 5. Underlying practical motivations like seizing assets and deterring others, cloaked in legal justifications. It wasn't that medieval lawyers were stupid. Far from it, they were often highly educated and steeped in complex legal traditions, but their framework of thinking, their assumptions about the world law and the afterlife were fundamentally different from ours. They built a logical to them structure upon these different foundations. It's like they were playing chess with entirely different rules, where the pieces moved in ways that make no sense if you're only familiar with modern chess. The need for public condemnation was also key. These trials were often highly public spectacles. The verdict, the punishment of the corpse, the confiscation of goods, it was all visible. This wasn't just about bureaucratic process, it was about performance. The public needed to see justice being done, order being restored, and the consequences of stepping out of line being brutally enforced. The dead person or their remains became a prop in this performance, a symbol of the condemned crime. Consider the psychological aspect for the living. Seeing the body of a known figure, perhaps someone who had been respected, subjected to this process reinforced the power of the authorities and the seriousness of the offense. It made the abstract concepts of treason or heresy brutally concrete. It also perhaps provided a strange form of closure or catharsis for a community shaken by a serious crime, even if the actual perpetrator was beyond reach. At least justice was done. They might think, however bizarre that justice seems to us, the entire process reveals a fascinating tension in medieval thought, the rigorous application of complex legal principles side by side with beliefs about death, sin, and judgment that seem almost mystical today. They meticulously followed procedures, cited precedents, often from Roman or canon law, and constructed detailed arguments, all while dealing with a defendant who was by all earthly logic incapable of standing trial. It's a window into a worldview where the boundaries between life and death law and religion, the earthly and the spiritual, were far more fluid and interconnected than we typically imagine them to be. And it all served the powerful. Kings used these trials to eliminate political enemies even after death and fill their coffers with forfeited wealth. The church used them to stamp out heresy and reinforce doctrinal control. Local lords might use them to deal with troublesome vassals and grab their land. The sophisticated legal arguments provided a veneer of legitimacy to actions that were often politically or economically motivated. As you walk on, leaving the courtroom square behind, you feel a new layer of complexity added to your understanding of this strange practice. It wasn't pure madness. It was a system of logic operating under fundamentally alien premises. A system that saw death not as an escape, but simply another state of being that the law must account for. A system where the body was more than just inert matter. It was a vestige of the person still subject to earthly judgment and disgrace. It's a heavy thought, and it makes you appreciate the relative simplicity of modern legal systems, where death is generally understood to put an end to earthly trials. Though maybe don't quote me on that, lawyers might find ways around anything. So you've grappled with the bizarre legal logic, the why of putting a dead person on trial, seeing how a combination of legal fiction, religious belief, and practical power dynamics twisted the concept of justice. Now let's pivot slightly and look at the how. Because dragging a decaying body into court every day for a potentially lengthy trial, then subjecting it to public humiliation and destruction, well, it presented some rather pungent logistical challenges, didn't it? Imagine the court clerk needing an extra supply of air freshener, or the bailiff complaining about the smell. It wasn't exactly practical for long, drawn-out legal proceedings or extended public spectacle. This is where things get perhaps slightly less grisly, but arguably even more symbolic, and perhaps in a way creepier. Over time, and not always consistently across regions or eras, there was a shift. Instead of using the actual physical decomposing corpse, the authorities sometimes opted for a stand-in, an effigy. Think of an effigy as a dummy, a likeness specifically created to represent the accused person. It could be anything from a roughly shaped figure made of straw or cloth to a more detailed wax or wooden sculpture, sometimes even dressed in the clothing the person would have worn or displaying symbols related to their crime or status. This effigy became the legal defendant. The trial proceeded exactly as it would have with a living person, or even with a real corpse. But it was this inanimate object that sat or stood or lay in the dock that was formally accused, that was presented with evidence, and that received the verdict in the sentence. Why make this switch practicality for one? As we mentioned, a real corpse starts to get unpleasant pretty quickly, especially if the trial drags on. Transporting it, preserving it impossible back then, keeping it presentable for public view. It was a logistical nightmare. An effigy, on the other hand, doesn't decay. You can parade it through the streets, hang it up in the town square for days, burn it publicly, dismember it. All the symbolic punishments without the biological mess. It's like the ultimate low-maintenance defendant, though it did lack the conversational skills, I suppose. Do you have anything to say in your defense? Silence? Right, moving on. But it wasn't just about avoiding the smell and the flies. The use of the effigy also reflected, or perhaps influenced, a subtle shift in the legal and symbolic thinking behind these trials. When you tried the actual corpse, there was a strong sense that you were punishing the physical remains, the vessel that had committed the crime. There was a visceral connection to the person. When you tried an effigy, the focus shifted more explicitly to punishing the persona, the legal identity, the memory, and the reputation of the deceased. The effigy wasn't the body, it was a symbol of the person and their actions. This distinction was important in legal theory. Medieval lawyers understood that the soul had left the body. While the body was a reminder of the earthly presence, the effigy represented the persistent legal existence of the person in the eyes of the court and the community, even in death. It was a way of saying, this person, John Smith, who committed treason, is still being held accountable by the law, even though he's no longer physically present. The effigy was the focal point for the legal process and the public condemnation. It was in essence the ultimate legal proxy. The use of effigies also allowed for a more controlled and impactful public spectacle. Imagine the difference between dragging a slumped, decomposing body on a hurdle through the streets compared to parading a figure crafted to resemble the person, perhaps dressed in mocking attire or holding symbols of their alleged crime. The effigy could be designed to elicit specific reactions from the crowd: disgust, anger, fear. It could be positioned and manipulated in ways a real corpse couldn't. It made the punishment less about desecrating physical remains and more about dismantling the symbolic representation of the person's public identity and status. A mainstream historical fact here is that the use of effigies in trials and punishments became increasingly common in the late medieval and early modern periods, particularly in France and other parts of continental Europe, for crimes like high treason. It wasn't just for deceased criminals. Effigies were also sometimes used to execute people who had fled or were otherwise unavailable, a practice known as execution in effigy. This highlights the legal system's need to assert its authority and deliver judgment even against those physically beyond its reach, blurring the lines between the symbolic and the real in striking ways. The effigy trial for the dead criminal and the execution in effigy for the living fugitive shared this core principle of the effigy standing in for the person. The shift to effigies might also represent a growing sophistication in legal thought. While the contumacy argument still applied the effigy like the corpse couldn't appear or defend itself, the focus was less on the physical body being the criminal object and more on the legal concept of the person being tried. Historians still argue whether the transition from corpse to effigy trials represented a softening of the law's brutality towards the physical remains or simply a more effective and controllable method of achieving the same punitive and symbolic goals. Was it a sign of slight legal progress, acknowledging the dead are just bodies, or just a clever workaround to make the morbid spectacle more palatable or perhaps more potent? Consider the symbolic power. An effigy could be dressed in the fine clothes the noble trader wore in life, only to be stripped and burned. It could be given the insignia of their office or status, only for them to be publicly broken or thrown in the dirt. This wasn't just about punishing the person. It was about undoing their public identity and disgracing their memory and lineage. The effigy as a representation was perfect for this kind of symbolic dismantling. There were, of course, different levels of effort put into these effigies. Some might have been crude figures barely human-shaped. Others were elaborate works of art commissioned from sculptors designed to be disturbingly lifelike, adding another layer of unsettling reality to the proceedings. Imagine seeing a detailed wax figure of your deceased family member being dragged through the mud and then hanged. That would stick with you, wouldn't it? It provided a powerful, tangible object for the crowd's revulsion and the authorities' demonstration of power. A quirky or fringe tidbit is that in some instances, especially in France, the effigy of the condemned traitor might be sentenced to exile after being burned or destroyed. Yes, you read that right. The effigy was exiled. This takes the legal fiction to an almost absurd level. Having already legally condemned and physically symbolically destroyed the representation of the person, the court would then issue a decree banishing the effigy from the realm. It's a perfect illustration of how the legal procedure, once set in motion, could follow its own internal logic even when applied to an inanimate object representing someone who was already dead and gone. It wasn't just about punishing the physical or symbolic form. It was about completing the full legal process, including steps that made no literal sense for the object being punished. The costs involved could also be significant, especially for elaborate effigies. These trials weren't cheap. The state or the church paid for the legal proceedings, the executioner, the materials for the effigy, and the public spectacle. This expense suggests that these trials, whether of corpses or effigies, weren't casual occurrences, but were undertaken when the authorities felt there was a strong political, financial, or doctrinal imperative to do so. They were tools of power used when a message needed to be sent with maximum impact. The transition to effigies also allowed the practice of posthumous punishment to continue even when the actual body was unavailable. Perhaps the accused died in a distant land, or their burial place was unknown, or their body had already decomposed beyond recognition. The effigy provided a convenient substitute, ensuring that death abroad, or discreet burial, didn't allow a high-profile offender to escape the formal judgment and consequences imposed by the authorities at home. Think about it from the perspective of the family again. If the actual corpse was tried, they had to endure seeing the remains of their loved ones subjected to this indignity. With an effigy, it was a symbol, yes, but perhaps slightly less traumatic than watching the physical body dragged through the mud. On the other hand, the effigy trial could be more drawn out. The public display of the effigy might last longer, prolonging the family's shame and the community's reminder of their disgrace. It's hard to say which would be better or worse for those left behind, but the shift certainly changed the nature of the public humiliation. The effigy trial also arguably reinforced the legal system's concept of the person as something that extended beyond mere physical presence. It treated the legal identity, the reputation, the name, and the actions of the individual as things that persisted after death and were still subject to earthly law. The effigy was the concrete manifestation of this persistent legal ghost. It's like their legal profile picture got put on a public blacklist, only instead of just blocking them, you could burn the profile picture. This practice of using effigies for symbolic trials and punishments persisted in some forms even after the peak era of actual corpse trials. Executions in effigy were carried out much later into the early modern period, particularly for high-profile individuals who had escaped justice. It demonstrates the enduring power of symbolism in legal and political control, and the authorities' persistent desire to punish and disgrace those they deemed enemies, even in absentia or in death. So while the corpse trial itself might seem like the height of bizarre medieval justice, the effigy trial represents an evolution of that practice driven by practicality and an increasingly sophisticated, though still alien to us, understanding of legal personhood and the power of public spectacle. It allowed the authorities to continue delivering posthumous justice, or vengeance depending on your perspective, in a more manageable, more controllable, and arguably even more symbolically potent way. It took the macabre reality of the corpse trial and transformed it into a chilling piece of political and legal theater, ensuring that even in death the condemned had no peace from the long, strange arm of medieval law. As you ponder this shift, you realize how deeply intertwined medieval law was with public performance and the manipulation of symbols, using every tool available, living dead or effigy, to assert its absolute authority. So you've seen how the medieval legal system, in its earnest pursuit of justice and symbolic power, stretched its reach even into the realm of the dead, finding ways to try and punish corpses and even effigies. It's easy to think that's the weirdest it gets, right? Trying a dead person. What could possibly be more bizarre than that? Well, hold on to your comfy pillow, because medieval justice wasn't done surprising us yet. Because alongside and sometimes intertwined with the trials of deceased humans were the trials of animals. Yes, you heard that right. Pigs, cows, dogs, even insects and vermin were sometimes dragged before secular or ecclesiastical courts assigned lawyers. Sometimes very expensive ones, presented with charges and subjected to formal legal proceedings, including sentencing and execution. Imagine the scene. A courtroom not too different from the one where that poor corpse was propped up. But instead of a decomposing human body, you might see a pig standing or being held in the dock, perhaps looking utterly bewildered or maybe just hungry. The prosecutor reads out the charges. Perhaps the pig killed a child, a depressingly common reason for animal trials. A lawyer robed and serious might stand beside the pig, ready to argue its case, citing legal precedents involving other animal defendants. It's like something out of a particularly dark and surreal cartoon, isn't it? You can almost hear the squeals of indignation from the accused. These animal trials weren't just informal lynchings or immediate punishments. They were formal legal processes conducted with surprising adherence to the rules and procedures of the time. The animal was arrested, often imprisoned, awaiting trial. Witnesses were called humans, testifying against the animal. Evidence was presented, and the animal was found guilty or innocent. If found guilty, the sentence could be severe, often mirroring punishments for human criminals. Execution by hanging, burning, or even being buried alive. Why would they do this? It seems utterly nonsensical to our modern minds. A pig bites a child, you deal with the pig, surely. But the legal minds of the time saw it differently. Just like the corpse trials, these animal trials were deeply rooted in the medieval understanding of justice, responsibility, and the relationship between humans, animals, and the divine. One key argument mirrored the contumacy principle used for corpses. Animals like the dead couldn't speak in their own defense. They couldn't answer charges, present alibis, or understand the legal proceedings. Therefore, they were considered contumacious, willfully disobedient to the court's summons and authority simply by their nature. This lack of ability to participate in the legal process somehow made them more subject to its formal judgment, not less. It sounds completely backward, doesn't it? You can't defend yourself, therefore you are guilty of disrespecting the court, therefore we must give you a formal trial and execution. It's a logic that really only makes sense if you view the process itself as paramount, more important than the actual capacity of the defendant. Furthermore, medieval theology played a significant role. While animals weren't believed to have souls in the human sense, they were part of God's creation, living in a world governed by divine and earthly law. An animal that committed a serious act like killing a human was seen as having somehow broken that natural or divine order. The trial and execution were a way to restore that order, to purify the community, and to appease potentially angered divine forces. It was a public demonstration that such transgressions, even by a beast, would not go unaddressed by the authorities who were responsible for maintaining order under God. A mainstream historical fact is that animal trials were a documented legal phenomenon in medieval and early modern Europe, occurring from the 13th century well into the 18th century, with numerous recorded cases across France, Switzerland, Germany, and other regions. These weren't just a few isolated incidents. Hundreds of cases are recorded in legal archives detailing the full judicial process applied to animals ranging from livestock to insects. Pigs, due to their close proximity to humans in villages and unfortunate tendency to injure or kill children who were often left unattended, were among the most frequent defendants. The practical purpose was also present, just like with corpse trials. An animal that had caused harm was a danger and needed to be dealt with. But a formal trial elevated this from a simple act of animal control to a public performance of justice. It sent a message to the community: the law is vigilant. Even a rogue pig cannot escape its reach. And if a pig is held accountable, how much more so will a human be? It reinforced the authority of the court and the seriousness of the laws it enforced, regardless of the defendant's species. Consider the symbolism again. When a pig was hanged in the town square, dressed in human clothes, which sometimes happened, it wasn't just about killing the pig. It was a spectacle designed to horrify and instruct. It showed the consequences of violence, even unintentional or animalistic violence within the human community. It blurred the lines between human and animal transgression in a way that reinforced the hierarchy of creation and the supremacy of human law. A joke here. Perhaps the animal defense lawyers were the first to argue diminished capacity, just, slightly more diminished. Your Honor, my client is a pig. With all due respect, his capacity for complex reasoning is limited to finding truffles and rolling in mud. Interestingly, ecclesiastical courts also tried animals, particularly pests like rats, locusts, or snails, often for damaging crops. These trials took a slightly different form. The animals wouldn't be brought physically into court. Imagine trying to herd thousands of snails, but they would be summoned through official proclamations read out in the affected areas. If they didn't appear surprised, they were declared guilty by contumacy and excommunicated. Yes, excommunicated. Imagine a swarm of locusts being formally cast out of the church. It seems absurd, but it was a deeply serious act within the medieval worldview, using religious authority to try and control the natural world. Historians still argue whether ecclesiastical animal trials were primarily acts of faith and attempts at supernatural intervention or sophisticated legal mechanisms for authorizing and mobilizing the community for collective pest control. Was it genuinely about spiritual condemnation or a clever way to get everyone organized with nets and fire? A quirky or fringe tidbit in the realm of animal trials involves the specific legal defenses sometimes employed. In one case from 16th century France, a sow and her piglets were on trial for killing a child. The sow was convicted and executed. However, the defense lawyer for the piglets successfully argued that there was no direct evidence that the piglets had participated in the act, only that they were present. He argued that they should not be held responsible for the crimes of their mother, essentially arguing for individual accountability even for baby pigs. The piglets were acquitted. This level of detailed legal argumentation applied to a litter of swine truly highlights the seriousness and legal formalism applied to these cases. It wasn't just a show trial. They were engaging with principles of evidence and complicity, albeit in the most unusual context. The comparison with human corpse trials is striking. In both cases, the defendant is incapable of participating meaningfully in their own defense. In both cases, the trial serves a purpose beyond simple retribution. It's about restoring order, asserting authority, and delivering a public performance of justice. The corpse trial punishes the lingering legal identity of a deceased human. The animal trial punishes the natural behavior of a beast that has crossed a boundary vital to human society. Both are deeply embedded in a worldview where law is not confined to the conscious, living, rational human, but extends to everything within the created order that interacts with human life. The costs involved in animal trials could also be considerable. Not only were there court fees, but there was often a lawyer's fee, sometimes paid by the local community or the victim's family, and the cost of keeping the animal imprisoned and eventually executing it. This economic investment further underscores that these were not trivial matters but serious legal undertakings. It's not every day you see a bill itemizing legal representation for one murderous pig, 10 shillings. The connection between corpse trials and animal trials highlights a unique aspect of medieval jurisprudence. It wasn't just about punishing intent or conscious wrongdoing in the way modern law focuses. It was also about dealing with the consequences of actions, regardless of the agent's capacity for moral intent. If a body, even a dead one, was the instrument of a crime, it could be subjected to legal process. If an animal caused harm, it too fell under the purview of the law. It's a form of legal responsibility that feels almost archaic, attributing culpability to the physical object or creature involved, not just the thinking mind behind it or lack thereof. These practices faded over time as legal thought evolved. The focus shifted more firmly to human intent and consciousness, and perhaps as societal anxieties about divine wrath or the blurring lines between humans and the natural world lessened. But while they lasted, animal trials were a very real, very bizarre part of the legal landscape, sitting right there alongside the trials of the dead. They weren't an anomaly. They were a consistent application of medieval legal principles to the non-human world, reinforcing the idea that the law's reach was vast and absolute. So as you drift towards sleep, consider this strange era where the boundaries of legal personhood were so fluid, so unlike our own, where justice wasn't just for the living and the rational, but extended its long, formal, and often nonsensical arm to encompass the deceased and the dumb beasts of the field. It's a reminder that our modern legal system, for all its complexities, emerged from a past that viewed the world and its inhabitants through a very different and profoundly unsettling lens. The squeals of the pig in the dock, the silent presence of the effigy, the decaying corpse on trial. They are all echoes of a time when law sought to impose order and extract justice from every corner of existence, living, dead, or animal. So you've waded through the peculiar world of corpse trials where the dead were brought low, and just when you thought things couldn't get any stranger, we dipped our toes into the frankly mind-boggling realm of animal trials where pigs could be defended by lawyers and insects excommunicated. It's a landscape of justice that feels utterly alien, a place where the physical presence, even of a non-human or non-living defendant, seemed crucial for the ritual of the law to play out. But what happened when the body wasn't available? What if the accused died far away, or perhaps even more inconveniently fled the jurisdiction entirely before the slow wheels of medieval justice could grind them up? The medieval legal system, surprisingly persistent and remarkably adaptable in its strangeness, had an answer for that too. If you couldn't get your hands on the actual deceased body, or the fugitive living one, you simply put something else in its place. You put the concept of the person, the legal identity on trial, represented not by their physical form, but by a stand-in. You used an effigy. Yes, the show, as the outline bullet promised, simply had to go on. Justice in the medieval mind demanded a public performance. It required a defendant, a court accusations, and a resolution, even if that defendant was dead absent or represented by a doll. An effigy trial wasn't just a symbolic gesture. It was a formal legal proceeding, often with the same gravity and adherence to procedure as a trial involving a living person or a literal corpse. Imagine the scene. The courtroom, perhaps the same one with the drafty stone walls and the faint smell of damp straw you pictured earlier. But instead of a body propped up, there's a figure. It might be a simple wooden mannequin, or perhaps more elaborate, dressed in clothes that were allegedly worn by the absent person, or perhaps just generic prison garb. This figure, this effigy, is placed in the dock. It represents the accused. It is the accused for the purposes of this legal ceremony. The charges are read aloud, directed at the silent, unmoving effigy. Witnesses testify against it, recounting the alleged crimes committed by the person it represents. A prosecutor makes arguments, perhaps gesticulating towards the wooden figure, as if it could feel shame or fear. And yes, sometimes though, perhaps less frequently than for corpses, the effigy was even assigned a lawyer. Can you imagine the job description? Seeking legal counsel for a block of wood. Must be proficient in arguing absence and inanimate silence. Benefits include minimal client interaction. It sounds absurd, but it underscores the deep formality and legalistic approach taken. A mainstream historical fact is that trials in effigy were a recognized legal procedure in medieval and early modern Europe, particularly for individuals accused of serious crimes who had fled or died before they could be apprehended or tried conventionally. These trials were often conducted as a form of public shaming and condemnation when the physical person was unavailable. It wasn't just a symbolic burning in the town square, though, that sometimes followed a guilty verdict against an effigy. It was a full, albeit often expedited, legal process leading to a formal conviction and sentence. The legal logic behind using an effigy stemmed from a couple of key ideas. Firstly, there was the concept of contumacy we encountered with the corpse trials. If a living person fled and refused to appear in court, they were considered contumacious, defying the authority of the law. A trial, in absentia, in their absence, was possible, but the physical presence of the defendant, or a representation of them, was often preferred for the public spectacle and ritualistic cleansing the trial represented. The effigy served as the physical manifestation of the absent defendant's legal persona. It was a way to make the absent present, at least in the eyes of the law and the community. Secondly, for deceased individuals whose bodies couldn't be retrieved, perhaps they died abroad or were lost at sea, the effigy served a similar purpose to the corpse in a regular corpse trial. It allowed the legal system to proceed against the memory and the legal identity of the deceased, even if their physical remains weren't there. The effigy stood in for the body that wasn't available to stand trial itself. It allowed the process of condemnation and often posthumous punishment or disgrace to be carried out publicly. Consider the spectacle. A trial involving an effigy was a powerful public performance. It reinforced the message that the law's reach was long and inescapable. Even if you fled, even if you died and your body couldn't be found, the legal system would still find a way to put you, or at least a representation of you, on trial, condemn you if found guilty, and often carry out a symbolic punishment on your stand-in. If you were on the run, hearing that your effigy had been tried and sentenced would be a clear signal that you were still a wanted person. Your property might be confiscated and your reputation publicly ruined. It was a way of projecting the power of the court beyond its immediate physical reach. Sentencing an effigy was serious. A guilty verdict against an effigy could lead to the destruction of the effigy itself, often in a manner mirroring the sentence that would have been applied to the person. If the crime warranted burning at the stake, the effigy might be publicly burned. If it was hanging, the effigy might be hanged. This public destruction of the effigy was a symbolic execution representing the state's claim over the absent or dead person's legal existence and their condemnation by the community. It was justice delivered by a puppet. Guilty off with his wooden head. A quirky or fringe tidbit about effigy trials is how elaborate they sometimes became. There are accounts of effigies being dressed in fine clothes or specific identifying garments to make them more clearly represent the accused. Sometimes they were even given masks with painted faces or hair resembling the person's. This level of detail suggests that the intention was to create a stand-in that felt at least visually like the person being judged, enhancing the sense of this being their trial even in absentia. It wasn't just a random dummy, it was meant to be them. It's like an early macabre form of celebrity impersonation, but with much higher stakes. These effigy trials weren't limited to common criminals. They were also used for political figures who had fled after treason or rebellion. Condemning a noble or a political enemy in effigy allowed the crown or ruling power to legally confiscate their lands and titles, even if they couldn't capture the person themselves. It was a way to enact legal consequences against a person's status and property, using the effigy trial as the necessary legal gateway. The distinction between a trial of a dead body corpse trial and a trial of an effigy of a dead body effigy trial for the deceased is subtle but significant. In a corpse trial, the physical remains seen as having a residual legal identity or somehow tied to the crime committed by the living person were present. In an effigy trial for a deceased person, the body was gone, but the need for the legal process to unfold publicly remained. The effigy stood in for the absent body, allowing the court to perform the ritual of judgment against the memory and legal status of the dead. It underscores that medieval justice was as much about the performance of law and the assertion of authority as it was about the specific fate of the physical individual. Historians still argue whether effigy trials were primarily symbolic acts intended for public consumption and political messaging, or whether they were considered truly legitimate legal proceedings with the same weight as trials involving living defendants. Was the effigy merely a prop in a political theater designed to delegitimize an enemy or frighten potential fugitives? Or did the medieval mind genuinely believe that the effigy, through the ritual of the court, could somehow absorb the guilt and punishment intended for the person it represented, thus satisfying the demands of divine and earthly justice? The idea of using an effigy is a clear evolution from relying on the physical body. It demonstrates the legal system's drive to formalize and ritualize justice, even when the ideal conditions a live present defendant weren't met. If a corpse trial was about bringing the physical remains to judgment, an effigy trial was about judging the idea of the person, the public persona, and legal standing using a physical substitute to ground the abstract concept in a concrete visual ceremony. Think about the costs involved again. Preparing an effigy, conducting the trial, sometimes even paying for its destruction in a public spectacle. These were not insignificant expenses. Like animal trials and corpse trials, the willingness to invest resources in these peculiar proceedings highlights their importance within the medieval legal and social structure. It wasn't cheap to burn an effigy, but the message it sent about the reach and power of the law was considered worth the price. The effigy trial is in some ways the logical conclusion of the medieval emphasis on legal form and public ritual over purely rational assessment of individual culpability or capacity for defense. Since the corpse or the animal couldn't truly defend themselves anyway, replacing the body with a stand-in didn't fundamentally alter the core nature of the trial, which was often geared towards public condemnation and the restoration of perceived order, rather than a nuanced assessment of guilt or innocence based on evidence presented by the defendant. It was less about who was in the dock and more about the fact that something was in the dock representing the transgression. The concept of an effigy trial might remind you a little of modern practices like burning someone in effigy as a protest, but the medieval version was far more formal, embedded within the legal framework itself, not just an act of public opinion or protest. It had legal consequences affecting property status and the legal memory of the person represented. It was a way for the state to legally execute judgment even when the primary target was beyond their grasp. It was justice delivered via a proxy, a ghost limb of the law reaching out across distance or death. As your consciousness begins to soften and blur around the edges, let the image of that silent wooden figure in the medieval dock settle in your mind. It stands as a testament to a legal system that prioritized its own procedures and public display so highly that it would literally invent a defendant if the real one wasn't available. The effigy trial, like the corpse trial and the animal trial, reveals a world where the boundaries of legal accountability were drawn in ways we find startling and strange. A world where the law sought to impose its will not just on living rational beings, but on the very fabric of reality encompassing the dead, the animal, and even the inanimate stand-in. It's another layer of medieval strangeness, another reminder that sleep brings us face to face with histories that are far, far removed from our own assumptions about justice and reality. So you've got the corpse summoned, the court has appointed a very patient representative, and now the proceedings really begin. The big question is, how do you prosecute someone who is quite literally beyond earthly questioning? How do you present evidence against a defendant whose most compelling argument is their own eloquent silence? It's one thing to read out charges against a living person who can shout objections. It's another entirely to build a case against a body that simply lies there, making no fuss whatsoever. The presentation of evidence in a medieval corpse trial followed broadly the procedures used for living defendants, but with all the inherent awkwardness you can imagine. The prosecution, often representing the injured party, the state, or the church, depending on the nature of the alleged crime, would gather evidence and present it to the court. This could include witness testimony, physical objects related to the crime, or documents. Imagine the scene. A solemn medieval official stands before the judge, and the silent deceased defendant reading out sworn statements or displaying items. Behold, Your Honor. You can picture them saying, perhaps holding up a piece of fabric or a bloodied object. Though medieval forensics were, shall we say, less advanced than a CSI episode, evidence linking the accused, thereof, to the heinous act. It requires a certain level of commitment to the bit. Witnesses would be called to testify. Now, testifying in medieval court wasn't always like a modern trial with cross-examination as we know it. Procedures varied widely depending on the time period, location, and type of court, secular versus ecclesiastical. But witnesses would typically swear on a holy text and recount what they knew or had seen. In a corpse trial, they would give their testimony directed toward the court, perhaps glancing occasionally at the silent figure of the deceased. Think about being a witness in such a trial. You've sworn an oath before God to tell the truth, the whole truth, and nothing but the truth. You're recounting events that led to someone being accused of a serious crime. Heresy, treason, murder, bestiality, you name it. And the person you're testifying against, they're dead. You stand there perhaps nervous, maybe intimidated by the setting, and you speak your piece while the accused lies or sits nearby, utterly immobile and unresponsive. It must have been profoundly unsettling. There was no opportunity for the accused to challenge your account, to protest their innocence directly, or to offer a different version of events. The defense, remember, was handled by the appointed representative, who had to rely on arguing points of law procedure, or perhaps attacking the credibility of the witnesses in a general sense, since they couldn't get any input from their client. The types of evidence presented could be incredibly varied, and sometimes included things we wouldn't consider evidence today. Oaths and compurgation, swearing innocence with the help of oath helpers, were crucial in many medieval legal systems, though how this worked with a dead defendant is problematic. You can't exactly get a corpse to swear an oath, and their oath helpers might be questioned on the basis that their principal was demonstrably deceased and thus perhaps less capable of celestial truth-telling. Physical evidence, while used, was often interpreted through a lens of superstition or divine intervention. For instance, the ordeal was a common method of determining guilt or innocence, where the accused would undergo a dangerous or painful test, like holding hot iron or being thrown into water, with the outcome interpreted as God's judgment. Again, applying this to a corpse is logistically challenging and profoundly pointless from a physical perspective. Though honestly, the thought of a medieval court trying to subject a corpse to an ordeal is almost darkly comedic. Right then, mister, so-and-so, let's see how you handle this red-hot poker. Oh, still dead. No divine intervention yet, I suppose. However, some more practical forms of evidence were certainly used. Witness accounts were primary. Documents, if they existed, could be presented. Contracts, letters, or official records. Reputation also played a significant role. If the deceased had a bad reputation while alive, this could weigh against them. Conversely, the defense representative might try to argue the deceased was a person of good character. The weight given to various types of evidence was a mainstream historical feature of medieval law, which often prioritized sworn testimony and oaths above what we might consider empirical evidence today. It was a system based on faith, reputation, and ritual as much as on verifiable facts. A quirky or fringe tidbit related to evidence in some historical accounts of similar trials, though perhaps more focused on animal trials which shared some conceptual overlap, involved the use of expert testimony. While less common for human corpse trials, the idea of bringing in people with specific knowledge to comment on the evidence existed. Imagine an early version of a forensic expert being called to examine a body that has been exhumed, trying to determine cause of death or time of death based on medieval knowledge, perhaps relying on humors or other now discredited theories. It adds another layer of peculiar formality to the proceedings. Historians still argue whether the standards of evidence applied in corpse trials were genuinely meant to be as rigorous as those for living defendants, or if the process was fundamentally skewed against the accused from the start. Given the inherent inability of the corpse to participate in its own defense or challenge evidence, it's hard to imagine it being a truly fair fight. Consider the testimony itself. Witnesses, perhaps neighbors or people who knew the deceased, would stand up and recount their stories. Maybe they saw the accused acting strangely. Maybe they heard them make incriminating remarks. Maybe they were the victim or a relative of the victim recounting the details of the alleged crime and the suffering cause. All this narrative unfolds in the courtroom, directed toward the judge and jury, if there was one, but always with the silent, central figure present. It transforms the testimony from a dialogue or potential dialogue, if the accused could respond, into a monologue delivered over the grave, so to speak. The defense representative's job during this phase was incredibly difficult. They couldn't consult with their client. They couldn't ask, "Were you really there that night?" or "Did you actually say that?" Their only recourse was to challenge the witnesses themselves or the evidence presented. They might try to poke holes in a witness's credibility, perhaps, by pointing out inconsistencies suggesting they had a motive to lie, or arguing their memory was unreliable. They might argue that physical evidence was misinterpreted or belonged to someone else. It's like playing chess with half the pieces tied behind your back, and the other player's king is already off the board, but somehow still dictates the game's outcome. Sometimes the sheer theater of the situation must have been overwhelming. You have the solemnity of the court, the gravity of the charges, the emotional weight of the witness testimony, and in the midst of it all, a dead body. It's a constant, stark reminder of the macabre nature of the proceedings. The smell might have been a factor, depending on how long the body had been dead and the conditions of the courtroom. Medieval buildings weren't known for their ventilation. You're sitting there trying to focus on the legal arguments while assaulted by sensory details that scream, "This is not normal." It's the ultimate distraction in court. Not a phone going off, but the defendant literally decomposing slightly in the dock. The purpose of presenting evidence and hearing witnesses against a corpse wasn't just about determining the deceased's guilt or innocence in some abstract sense. As we touched on before, there were very real, tangible consequences tied to the verdict, primarily for the deceased's property, reputation, and surviving family. Conviction could lead to confiscation of assets, effectively disinheriting the heirs, and sometimes leaving the family destitute. It could also permanently stain the family name. So while the accused couldn't suffer further physical punishment, short of perhaps post-mortem desecration, the trial served a crucial function for the living community and legal system. It provided a formal process for determining whether the deceased's worldly goods and legacy should be treated as those of a convicted criminal. The evidence and testimony were therefore directed towards proving the case to the satisfaction of the court, so that these consequences could be enacted. In cases involving heresy or treason, the stakes were particularly high, not just for property, but for the deceased's eternal soul in the eyes of the church. While the earthly court couldn't condemn a soul to hell, A finding of guilt for heresy by an ecclesiastical court could have spiritual consequences, such as the denial of Christian burial or excommunication even posthumously. So for believers in the medieval world, the outcome had spiritual as well as material significance. The presentation of evidence and the witness testimony weren't just about proving a crime. They were about determining the deceased's status before both earthly and divine judgment. Imagine the weight on the witnesses. Testifying against someone after they are dead removes the fear of immediate reprisal from the accused, but adds a different kind of pressure. You are speaking against someone who cannot defend themselves, whose fate and that of their family rests significantly on your words, and who is in a very real sense beyond your reach. It's a powerful and potentially dangerous position to be in, especially if there were doubts about your testimony, or if the deceased had powerful friends or family who might seek retribution later. The process of gathering testimony might involve investigators visiting the area where the crime occurred, or where the deceased lived. They would interview people, collect statements, and bring this information back to the court. Sometimes these statements might be presented in written form, read aloud during the trial. Other times, the witnesses themselves would appear in person. The formality of this process, even when dealing with a deceased defendant, highlights the deep-seated need within the medieval legal system for established procedures and documentation. It wasn't just a mob lynching. It was an official, albeit bizarre, legal proceeding with rules, however strange they seem to us, that had to be followed. The defense representative, having heard the evidence and testimony, would then have to construct their counter-arguments. Again, this was limited. They might argue that the witnesses were mistaken or lying. They might argue that the evidence was circumstantial or had been tampered with. They might argue that the alleged crime wasn't actually a crime under the relevant law, or that the deceased was incapable of committing it, though arguing that someone was too dead to commit a crime would likely have been a non-starter for anything that happened before their death. Their role was to introduce doubt to challenge the prosecution's narrative within the constraints of defending a silent, absent-minded client. The court in its deliberation would weigh the evidence and testimony presented. They would consider the sworn statements of the witnesses, the nature of the physical evidence, if any, and the arguments of both the prosecution and the defense representative. The judge or jury, depending on the court, would then come to a verdict. All of this built upon the foundation laid in the earlier stages, the formal accusation, the summoning of the corpse, however symbolically, and the appointment of a representative. The trial was the central act where the case was formally laid out, assessed, and decided. It's a grim tableau, isn't it? Witnesses solemnly testifying, officials presenting evidence, a defense lawyer arguing against silence, and the quiet, still figure of the deceased at the center of it all. It speaks volumes about the medieval mindset, their relationship with death, their legal philosophies, and their understanding of justice. It wasn't just about punishing the individual. It was about restoring order, affirming community values, and dealing with the messy consequences of death when serious accusations were involved. The evidence and testimony phase was where the living world attempted to impose its judgment upon someone who had already left it. So you've sat through the solemn readings of the charges, watched the awkward presentation of evidence against a silent, still figure, and listened to the careful, limited arguments of the deceased reluctant representative. Now comes the part where the gears of medieval justice grind towards a conclusion. The evidence has been laid out, the witnesses have spoken, and the court must decide. How exactly do you weigh the guilt of someone who is already beyond the reach of earthly prisons or physical pain based on testimony delivered over their unmoving form? It feels like judging a statue based on what passers-by say about it. The process of reaching a verdict in a medieval court varied considerably depending on the time, place, and nature of the court, secular or ecclesiastical, local or royal. However, the core principle was that the court, whether a single judge or a jury, sometimes of your peers, sometimes of respected local men, had to deliberate based on the information presented. In a corpse trial, this deliberation took on an even stranger hue. You as a juror or even the presiding judge would retire to consider the case. You'd discuss the witness testimonies. Did they seem credible? Were there inconsistencies? You'd look at any physical evidence trying to interpret its meaning through a medieval lens that might blend practical observation with signs and portents. Imagine being one of those jurors. You're a local merchant, perhaps, or a farmer pulled into this formal bazaar setting. You're sitting in a room, maybe damp and cold, discussing the fate of someone you might have known in life. The baker down the street, the blacksmith from the next village, or perhaps a total stranger accused of heinous crimes far away. And the core of your deliberation is, did this person, now dead, do the terrible thing they're accused of? You have sworn oaths, you have heard testimony, but the accused is not there to offer a single word in their own defense, not even a ghostly whisper. Your only guide is the likely underwhelming defense offered by their appointed representative. The deliberation process itself could involve heated arguments, quiet prayer, or attempts to find consensus. In some medieval systems, reaching a verdict required unanimity, which could lead to lengthy and difficult discussions. In others, a majority was sufficient. The pressure was immense. Your decision didn't just impact the deceased's abstract reputation. It had profound, concrete consequences for their surviving family and their worldly possessions. You were deciding whether a family would be made destitute, whether their name would be forever tainted, whether they would lose their home and livelihood. All because of something their now dead relative was accused of doing. Sometimes the weight of the decision might have felt overwhelming, pushing the court towards seeking divine guidance, even beyond the initial oaths. While the ordeal was generally not applied to corpses, the mentality of seeking a clear sign or trusting in providence might still linger in the deliberation chamber. You could imagine jurors praying together, asking for clarity or looking for subtle signs or omens within their own discussions. After all, they were judging someone who was now presumably before a higher court themselves. It added a layer of spiritual anxiety to the very practical matter of determining earthly guilt and its consequences. Once a decision was reached, the court would reconvene to deliver the verdict. This was often a formal and public affair. The judge would announce the court's finding guilty or not guilty. The atmosphere must have been thick with tension, especially if the family of the deceased was present. The silence of the courtroom punctuated only by the judge's voice declaring the fate of a dead person, and their living heirs must have been incredibly dramatic and frankly unsettling. A verdict of not guilty while seemingly possible, was likely rare for cases that proceeded to a full trial of a corpse. These trials weren't typically initiated lightly. There were usually strong accusations, often with significant community impact driving the process. If a not guilty verdict was delivered, it would effectively clear the deceased's name in the eyes of the law, and crucially protect their property and family from the severe consequences of a guilty verdict. The deceased's reputation would be restored as much as possible, and their heirs would inherit their estate without encumbrance related to the accusation. It was a declaration that despite the grim circumstances in the formal legal process, the deceased was deemed innocent of the specific charges brought against them. However, the much more common outcome, or at least the one that historical accounts tend to focus on, was a verdict of guilty. And it is here that the true purpose and consequences of these corpse trials become starkly apparent. A guilty verdict triggered a cascade of penalties that, while they could not harm the deceased, physically devastated their legacy and their living family. The most significant and often the primary driver behind the pursuit of such trials, at least according to some historians, was the confiscation of the deceased's property. This is a mainstream historical fact of medieval law. When a person was convicted of serious crimes like treason, heresy, or felony, their property was typically forfeited to the crown, the local lord, or in some cases, the church. A guilty verdict against a corpse meant that their entire estate, land houses, money goods, livestock, everything, could be seized by the authorities. This wasn't just a symbolic gesture, it was a significant transfer of wealth. For the deceased family, this meant immediate and total disinheritance. Wives could be left penniless, children turned out of their homes with nothing. It was a brutal economic consequence of a trial against someone who couldn't even feel the pain of loss. This forfeiture system provided a strong incentive for the powerful to pursue these cases. Accuse a wealthy individual, even posthumously, of treason or heresy, secure a guilty verdict, and their substantial assets become yours. Historians still argue whether the primary motivation for these trials was genuine legal or religious justice, or if financial gain through the confiscation of assets played a significant, perhaps even dominant role. It's easy to see the cynical perspective when you look at the outcome. Beyond property, a guilty verdict had devastating consequences for the deceased's reputation, and by extension, the reputation of their family. In medieval society, family name and honor were incredibly important. A conviction, especially for crimes like heresy or treason, brought shame and disgrace upon the entire lineage. The family might be ostracized by their community, their social standing ruined. Even generations later, the stain of the ancestors' posthumous conviction could linger. It was a form of punishment that reached out from the grave to afflict the living. Sometimes there were also specific posthumous punishments applied to the body itself, although these are often described in conjunction with particularly heinous crimes like treason and were usually aimed at maximum public humiliation rather than any belief the corpse felt pain. While we're keeping things PG-13, historical records mention things like bodies being exhumed and dragged through the streets hanged or beheaded before being buried in unconsecrated ground. These were less about punishing the dead and more about serving as a grim warning to the living, a final public act of condemnation against the individual and the crimes they represented. It's another layer of the bizarre spectacle, the official apparatus of the state carrying out a symbolic, degrading punishment on something that is no longer capable of suffering. For cases involving heresy judged by ecclesiastical courts, which also sometimes conducted corpse trials, a guilty verdict had profound spiritual implications in the eyes of the church. The deceased would be formally declared a heretic, which meant their soul was considered damned. While the earthly court couldn't enforce this, it had practical consequences like the denial of Christian burial. The body might be exhumed from consecrated church ground and buried elsewhere, perhaps at a crossroads or outside the city walls, places traditionally associated with criminals and outcasts. This was a deeply feared punishment in a devout society, a final separation from the community of believers, even in death. A quirky or fringe tidbit related to the consequences concerns the disposition of confiscated goods. While the bulk often went to the crown or lord in some specific local customs or charters, portions of the forfeited property were sometimes earmarked for surprisingly specific uses or individuals. You might find records mentioning that after a posthumous conviction and confiscation, a certain sum was allocated to repair a specific bridge, or that the judge presiding over the case was entitled to a particular item from the estate as part of their fee or as a perquisite of their office. Imagine the officials sifting through the deceased's belongings, deciding which silver cup goes to the king, which piece of land to the local baron, and which embroidered cushion the judge gets to take home. It turns the solemn act of justice into a slightly grubby administrative carve-up of a dead person's stuff. The formality with which these consequences were enacted underscored the seriousness of the court's verdict. Officials would arrive to seize the property, inventories would be taken, and legal documents drawn up detailing the forfeiture. If a posthumous punishment of the body was ordered, it would be carried out publicly, adding to the spectacle and the lesson for the onlookers. These weren't backroom deals. They were official acts of the legal system flowing directly from the formal verdict reached in the trial. The family, having potentially sat through the entire trial process, would then face the immediate aftermath. Watching their relatives' name dragged through the mud, their character attacked, and ultimately seeing them declared guilty, followed by the swift seizure of everything they owned. It must have been a devastating experience, compounding the grief of losing their family member with the trauma of legal and financial ruin. They had no real recourse. The verdict of the court was final, at least in the earthly realm. These consequences, the loss of property, the ruin of reputation, the potential desecration of remains, the spiritual condemnation, were the true punishments inflicted in a corpse trial. They bypassed the deceased, who was beyond physical sensation, and landed squarely on the living survivors and the deceased's memory. It highlights how medieval justice was not solely focused on the individual criminal, but also on the restoration of social order, the affirmation of religious dogma, especially in heresy cases, and the often significant economic impact on powerful authorities. The verdict wasn't just a statement of past guilt. It was a legal mechanism for reshaping the present and the future for those connected to the deceased. The formal declaration of the verdict concluded the trial itself. All the strange procedures, the summoning, the representation, the bizarre evidence presentation, it all culminated in that final pronouncement. And with the pronouncement came the immediate activation of the consequences. The legal file on the deceased was closed, their guilt or innocence officially determined, and the wheels of property transfer and reputational damage began to turn. The court had done its work applying its unique brand of posthumous justice. All that remained were the echoes of the verdict and its very real impact on the world the deceased had left behind. So the verdict is in. The consequences are laid bare. Property seized, family disgraced, maybe even a gruesome final indignity for the remains. The curtain falls on this specific bizarre legal drama. But what happens next? Where do these corpse trials fit into the grand sweep of history? Do they just disappear like a bad dream? Or do they leave any sort of lingering mark? You've seen the inner workings, the strange procedures, the motivations both legal and potentially financial. Now let's look at the exit, the slow fade of this practice from the legal landscape. These corpse trials didn't vanish overnight. They weren't suddenly declared illegal or irrational by some enlightened decree. Instead, they gradually faded as legal systems evolved, as societal priorities shifted, and perhaps as people just collectively started thinking, okay, maybe this is a bit much. The peak era for these kinds of proceedings seems to have been the later Middle Ages and into the early modern period, roughly from the 14th to the 17th centuries. After that, while the legal concept of attainder conviction leading to property forfeiture, sometimes applied posthumously, persisted in some forms. For much longer, the full-blown spectacle of putting a physical corpse on trial became increasingly rare. One major factor contributing to their decline was the gradual development of more sophisticated and arguably more rational legal systems. As common law traditions strengthened, as the emphasis shifted towards mens rea, the guilty mind, and the practicalities of evidence and testimony involving living individuals, the idea of formally trying someone incapable of intent or response started to seem increasingly anachronistic. Courts became less focused on symbolic rituals and more on the direct administration of justice to living offenders. The legal framework simply outgrew the need, or perhaps the tolerance, for such peculiar proceedings. The rise of centralized state power also played a role. While powerful lords or the crown often benefited financially from corpse trials through forfeiture, the legal machinery of the state became more standardized. Royal courts and centralized justice systems often had less patience for the sometimes convoluted local customs or the ecclesiastical fervor that might have fueled these trials. They were more interested in apprehending and punishing living criminals who could pose an ongoing threat to public order rather than relitigating the actions of the dead unless there was a truly compelling political or financial reason. And even then, simpler legal mechanisms for confiscating the property of traitors, even deceased ones, emerge. Religious changes also contributed, particularly regarding heresy trials. The Reformation and the subsequent fragmentation of religious authority in Europe meant that the powerful pan-European reach of the Catholic Church and its ecclesiastical courts, which were often keen on pursuing heretics, even posthumously waned in many regions. While religious zeal didn't disappear, the legal mechanisms for enforcing it, especially against the dead, became less standardized and less universally accepted. The focus shifted more towards policing the beliefs of the living population. As these trials became less common, they likely also lost some of their social or political utility. The public spectacle, which served as a warning to the living and a means of asserting authority, might have become less impactful or even viewed with skepticism by a populace becoming more accustomed to different forms of justice. The sheer weirdness of it, which perhaps initially served a purpose in a world steeped in symbolism and spiritual anxieties, might have started to feel less like solemn justice and more like, well, like trying a dead guy. A mainstream historical fact is that legal systems across Europe underwent significant evolution from the late medieval period onwards, becoming more centralized, professionalized, and focused on codified laws and procedures concerning living individuals. This slow, steady evolution naturally pushed practices like corpse trials to the fringes. They didn't fit neatly into the emerging framework of justice, focused on criminal intent and correctional punishment of the living. Yet while the formal trials faded, the concept of posthumous consequences lingered in some forms. The idea that a person's actions could still impact their family and property after death didn't entirely disappear. Laws regarding treason and attainder, which allowed for the forfeiture of property and the disinheritance of heirs based on the ancestor's crime, persisted in many countries for centuries, sometimes even applying if the conviction occurred posthumously. This was a more direct, less theatrical way of achieving one of the primary outcomes of a corpse trial, stripping the deceased's family of their inheritance. So while you might not see a body in court anymore, the chilling economic penalty for being related to someone deemed a villain by the state could still apply. Historians still argue whether the decline was primarily due to legal reform and changing notions of justice, or simply because the financial benefits of confiscation became easier to achieve through less cumbersome legal means. It's a bit of a chicken and egg scenario. Did the law become more rational and therefore these trials became less appealing, or did authorities find simpler ways to seize assets and therefore stopped bothering with the elaborate spectacle of a corpse trial? Probably a bit of both, wouldn't you say? If you can get the gold without putting on a whole show with a rotting body, why wouldn't you? It's much less paperwork, and you don't have to worry about finding someone willing to represent the deceased. One quirky or fringe tidbit related to the very end of this practice involves specific instances where corpse trials were recorded quite late, almost as relics of a bygone era, sometimes linked to particularly sensitive or politically charged cases. There are accounts, though debated and sometimes hard to verify definitively, of trials or quasi-trials of deceased individuals popping up in places like post-Reformation Scotland or during periods of intense political upheaval in other parts of Europe, often connected to accusations of treason or particularly heinous crimes. These feel less like part of a functioning legal system and more like desperate symbolic acts of condemnation, perhaps used when the living perpetrators had fled or died. But the authorities still felt a need to make a powerful public statement against the perceived crime and legacy. It's like the legal system giving one last dramatic shudder before completely letting go of the practice. So you can imagine these trials becoming increasingly rare through the 17th and 18th centuries, viewed perhaps with a mix of fascination and discomfort, even by people at the time. They would be seen as part of the old ways, perhaps referenced in legal texts or histories as curious examples of past jurisprudence, but no longer a standard tool in the justice system's belt. The practicalities of handling a decaying body, the inherent illogic of trying someone incapable of defending themselves, the evolving understanding of crime and punishment focused on the living individual, all these factors conspired to make the corpse trial a relic. Its legacy, though, isn't just a historical curiosity. It serves as a vivid, if unsettling, reminder of how dramatically legal systems can differ from our own, how justice has been conceptualized and applied in ways that seem deeply alien today. It highlights the importance of ritual and symbolism in past legal processes, the interconnectedness of the individual, their family, their property, and their reputation in medieval society, and the very real material consequences that flowed from formal legal declarations, even those made against the dead. You've journeyed through this strange corner of medieval law, from the initial accusation echoing through the community to the formal summoning of the deceased, the search for a reluctant advocate, the bizarre courtroom proceedings with an unmoving defendant, the presentation of evidence, the heavy deliberation, and finally the verdict and its devastating impact on the living. You've seen the practical concerns, like finding a suitable representative or dealing with the physical presence of the body, rub shoulders with the abstract legal and religious principles at play. It's a window into a world where the boundary between life and death, between spiritual judgment and earthly law, seem far more permeable, at least in the eyes of the court. Thinking about these trials makes you appreciate the foundations of modern justice systems: the right to a fair trial, the presumption of innocence, the focus on punishing the living perpetrator, the separation of legal consequences from spiritual fate, at least in secular courts, in the protection of innocent family members from the direct financial ruin caused by an ancestor's crime. While our systems are far from perfect, the sheer unvarnished strangeness and harsh consequences of the corpse trial highlight the progress made in developing more humane and rational approaches to justice. It's a powerful reminder that history isn't just about kings and battles. It's also about the everyday, or perhaps in this case, the very everyday workings of society, the rules people live by, and the sometimes baffling ways they tried to make sense of the world and impose order upon it. And sometimes that order involved putting a dead person on trial. So there you have it. The story of the medieval corpse trials, the ones that historians might talk about, but rarely make it into the mainstream narrative. A peculiar, almost unbelievable footnote in the history of law, but one that offers a surprisingly rich insight into the minds and methods of people who lived long ago. It's a tale of justice, property, reputation, and the ultimate inability of death to fully escape the reach of earthly laws and the consequences they impose, especially on the living. You've now walked through that courtroom, felt the strange tension, and witnessed a process that feels utterly alien to our modern sensibilities. Hopefully, the sheer weirdness of it all has been just interesting enough to keep you from drifting off too soon, but gentle enough to start winding down your mind for the night. The gavel has fallen, the case is closed, and the echoes of this strange history can now fade away. Okay, the journey into the strange world of medieval corpse trials is complete. The legal proceedings are over, the consequences are felt, and the practice has faded into history. It's time to leave the courtroom and ease back into the quiet of the night. Now let the historical echoes soften. The formal language of the court, the weight of the evidence, the rustling of old documents, they all recede. You can let go of the images of the somber courtroom, the silent figure, the worried faces of the family. That part of the story is done. Your mind can begin to transition from the details of this peculiar past to the simple quiet of the present moment. Feel yourself settling deeper wherever you are. The history, as fascinating and strange as it is, has served its purpose for the night. It's time for your own thoughts to slow down, to become softer and less insistent. Imagine the courtroom doors closing, the torches flickering out, leaving the space silent and still. Just like that, you can let the story dim in your awareness. There's nothing more to think about, nothing more to analyze. The past is past and the present moment is here, quiet and peaceful. Just focus on your breathing, the gentle rise and fall, the soft sounds around you. Feel the comfort of your bed or chair. Everything is still and calm. Allow yourself to drift now, carried away from the strangeness of the past, towards the quiet peace of sleep. The trials are over, the night is calm, and you are safe and warm. Sleep soundly.